What do you have, Mr. Hoffman? Every time mentioning every day.
Well, in item number 30 million, island is not active. Yes, sir.
Item number?
30 million.
You don't like the number?
But it's still not active. Highly yesterday, madam. That's why I'll report.
Okay.
The admission method. So they want to come in late method. It is related to the composition of the land and combustion and it
Ben 5.
is Malad in IT seven, I have Thailand reflect if I love 27 Malad. Yesterday, that may paper for whatever. In item number 19,
Huh? You want to call that?
That's my question.
Okay.
Thank you so much. I didn't know what I filed the affidavit yesterday. The industrial record.
Let's have this matter some other day.
Fine.
This will require now before vacation.
Fine.
Huh?
Fine.
It has been submitted that an additional affidavit has been filed on behalf of the petitioner. Taking into account the above, let this matter be listed again on 23rd of January 2026. In the meantime, the respondents are given the liberty to file a rejoinder to the said, file a reply to the said additional affidavit, if so advised. The said affidavit reply has to be filed on or before 21/2025. Oh, again, so this day, you see, 22nd of it's going on, and they are to file by 19th. Anyway, now I'm starting to remember all things. Item?
16 option.
Yes.
Yes.
What do you want?
As you stage, give us the urgently tax, maybe a job for the day option.
The senior is not there. It's a 2017 matter. Does it look good? Tell me. We will not adjourn it. We'll try to allow you to argue. And if you are not successful, then I'll allow. Okay? Oh, that matter.
Yes.
There is an interim order where there is a proceeding, another proceedings for where an appeal has been filed out there before the LR. And it's pending. I passed an order that there should be a stay. You want an adjournment? Okay, we have it after 6 months. No. There's the interim order operating against you, then also you are asking for time. Don't take an interim order. We'll see when the matter reaches. Let her come up with the arguments. See, she will take an adjournment. Don't worry. Item? Tomorrow. What do you want? No. If you have filed the affidavit, it's before me, no? It's not required. No worry. Don't worry. I'll take care. It has come before me tomorrow. Okay. Don't worry. Take care. When?
Tomorrow.
Okay. I won't be taking it up. I think the other bench will be. I'm rising early tomorrow, 12 noon. Permission granted. Why, it can't wait till Monday?
The issue in question is whether the excise department has raised the demand for absolute levy under the 1910 and 1910 Act and the warehouse rules of 1965. Now the stock question was destroyed at the expense of the excise department because it was entered.
I passed the judgment in that
Yes,
regard.
but that it is slightly different because one of the levy would only come in.
Oh, no, I didn't pass the judgment. Justice Chaudhary has passed the judgment. I was thinking of the matter, then the matter went to Justice Chaudhary. He has passed the judgment.
Yes,
in
yes,
that.
Manoj, that issue.
Where there was a direction to permission was taken from somebody, and thereupon it was done. You have it today, if you want.
It's not there, Manoj, yet, but the filing is being done, perhaps it will not come up.
Sure. Then what is the urgency?
One of the excise department has issued the demand notice wherein they have stated that if the payment is not made within a period of time, the license will be cancelled. That is the urgency.
So what is the time?
It is still tomorrow.
Okay, tomorrow. Tomorrow we dismiss it. then.
Supplementary item 18, extension 30.
Okay? Oh, that one, yes.
We have taken instruction. Taking into consideration the financial position, only request is some more lenient to if 2 lakh per head is they agree. Financial condition is otherwise.
You have made a lot of money during your heydays. At that point of time when these petitioners were, the persons were working.
COVID at that time.
COVID has, because of the COVID, the newspaper industry has stopped.
Not like that.
Only thing which was permitted during the COVID is the newspaper. Isn't it? I still remember during the COVID period, this is done. Either accept the 3 lakh thing, which I think he will agree. You agree?
Proceed, I think clients, I just make them understand your role.
But they are not agreement.
Otherwise, they will agree your role. Only thing they want me to place for that their entitlement in terms of the, not in terms of the order, because order directed them to pay as per Mazichia, we are not claiming your order. Then it will come around 9 lakh
Per head.
per head.
I think 3 lakhs won't be good proper, so I'll dismiss your petition.
Proceed, we'll pay 3 lakh. I have already communicated in that case. But if we only that we will be paying improved stock. That we have already communicated.
Now you want 3 lakh. Just now you said 2
I
lakh.
said a lenient view can be given because.
No, I think it's a case for dismissal. They are entitled to 9 lakhs. 9 lakhs into 8, 72 lakhs. I'm dividing it by 300%. The discount I'm giving you.
Lordship may take the view that since our.
My view is not there. I don't have a view. My view is to dismiss your petition. But if I dismiss your petition, you know the fallout and the entire industry will close. Because the amount is very high. So I asked him, whoever the council was, to take it up, okay, pay him 3 lakhs each and we can close the issue. But the fact that you are now wants to bargain with this court, then obviously,
That was not our intention.
there
We
is
just take
nothing.
into consideration
I think we should
Yeah,
be
yeah,
going
yeah.
to, why should I aid you a helping hand to the prejudice of the petitioner respondents? What do you say, Mr. Bhattakur? 3 lakhs?
Lordship,
Do you agree?
3 lakhs, your lordship.
Per head.
Comparison to their fees, a small still your lordship. Looking into the other. That's fallen from your lordship, small, that's why I have.
I said 3 lakhs because of the fact that the question of another aspect is to be looked into. Is there many questions comes as regards back wages and all.
Lord,
which gives a discretion upon the court to grant you the backwardness or not. So therefore, if it could be ended there with 3 lakhs, then I think it is a fair thing for, because you see, one also has to see if there is, yes, they are wrong out there, but if we put it in this manner, the entire industry will finish. One also has to take note of that the print industry is going through a turmoil in view of the digital industry. Nowadays people, for me, although I have subscribed to various newspapers, I don't get the time. Better off me going through the digital media, the digital thing where you get everything, the e-papers and everything, you get it. And that is only affecting. Now that people also don't go for the e-paper also. This is also hampering the industry. So if that industry is closed, that it will lead to closure of the industry. If you can work out that 3 lakhs, I think it is fine. Have a word with your client.
No, I have already, or I have impressed upon, I have made them understand the tax or also. And they are active.
Then both of you agree and come up with the joint affidavit.
Lots.
You agree to 3 lakhs
Yes.
per head,
You will pay in 2.
and that installment has to be over by April 2026.
First in January, within January, second within April.
Second before Bihu.
Before we go.
Bihu, what is this? We go as per Bihu, our new year.
Lots.
Yes. Okay. The learned counsels appearing on behalf of the parties have made a submission that some form of a negotiated settlement have been arrived at between the parties, and they would like to file an additional a joint affidavit so that the issue involved in the present petition can be given a closure. List this matter on 17th at 2 p.m. In the meantime, the joint affidavit be filed. 13th April is the last prior to that period.
I think 17 for we could not upload all the documents. We could not upload all the documents. On 20 the option was there, toilet conversion. That is the first case and hopefully all the public toilet will be good.
Which newspaper? Oh, ASTC.
Yes.
You've given the copy to Mr. A. Samoa.
Some of it are doing. Oh my God. Then come to me.
Let us take it after some time. You are asking for some interim directions.
No, Bhagat, tomorrow is the last day. Let them take instruction, there is a provision for Bhagat, calling for shortfall of the local. I find myself in one of the cases of this, when there is shortfall of.
Oh, that toilet.
Toilet.
You are a beneficiary of an action taken by this court.
No, I'm not a beneficiary.
You are a beneficiary. Otherwise, this toilet was already there for 3 years.
There I was beneficiary and it was cancelled now, it is there.
Oh, so you are also affected.
I want to participate in the event.
Ah.
Petitioner could deposit, could upload only the event data. The other documents he could not upload.
Why?
He could not because the technical glitch is there. So normally, madam, all that point in one of the cases, they call for the short form document.
So what is the last date?
Tomorrow.
Okay, we'll take it up. Don't worry.
They were to carry this.
No, let us hear him also. Mr. We'll take it after when Mr. Samoa.
Or at least an item to part her.
Partner matter, what is this partner business?
raised to our own as needed. Regardless of petitions by law, that is one newspaper. And with regard to number of letters that have participated by law, I love about 3% second.
First time you publish in properly.
Yeah. And
Second time, why was it done in this manner?
And first time it was published by law and thereafter it was recorded. Again, publication by law in newspaper it has been given to the EPI vendor, but it got published in the Boro newspaper.
So then,
And it should go by law. Highest revenue should come in.
there is a big problem, which is earlier in the BTC. That led to that order, you remember?
Yeah.
Yesterday, there was this matter
Yeah.
taking up.
He did very
There also they were doing this. First of all, you see, many people may not understand the language, Boro language, but if they are within the ambit, they may not read the newspaper. So it is to be given in Assamese and one Boro language newspaper. So, but what is it? You are the highest bidder.
Yes, in the first ballot tender,
Ah.
you got fourth highest,
Huh?
fourth highest,
Fourth.
fourth highest
So why will you get it?
in the first tenders. But that was cancelled.
Or the second time you could not participate?
Second time that was not circulated.
So we give up the first one. I have nothing to say. But as regard the second one, we cancel it, we interfere with, and asking them to go ahead with a fresh tender by publishing in so and so. Heard Mr. M.U. Mondal, the Lalit Council, appearing on behalf of the petitioner. Mr. A.K. Bhuya, the Lalit Senior Standing Counsel of the BTC. Host. The petitioner herein is aggrieved by the action on the part of the respondent authorities in cancelling the tender process initiated by the notice inviting tender dated 24/3/2025 for settlement of, what is that? For settlement of 6/75 Bhelakoba Group Fisheries of Kokrajhar district. And thereupon, cancelling this, and upon cancellation of the said tender process, going ahead with a fresh tender process. Without proper publication. The facts of the instant case, the facts as it appears from the materials on record, is that on 24/3/2025, the Joint Director cum CDH Fishery Department Group, BTC Kokrajhar, had issued a notice inviting tender for settlement of various fisheries, including 6/75 Bhelakoba Group Fisheries of Kokrajhar district for 3 years. The petitioner participated in the said tender process along with various other bidders. The said tender was opened on 24/3/2025 And out of the 8 bidders, 5 bidders were found to be eligible. 5 bids were found to be valid. It is the further case of the petitioner that the petitioner was the highest eligible bidder. Be that as it may, a corrigendum was issued on 2/5/2025, whereby the NIT dated 24/3/2025 was cancelled due to some administrative reasons by the Joint Director cum CHD, Fishery Department, BTC, Kokrajhar. Subsequent thereto, it is the further case of the petitioner that another notice inviting tender was issued on 5/5/2025 by the Joint Director cum CHD, Fishery Department. For settlement of various fisheries, including 6/75 Helagopa Group Fisheries of Kokrajhar District, fixing the tender value at rupees 1,70,000. With the same terms and conditions as stipulated in the NIT dated 24/3/2025. As there was not wide publication of the said notice inviting tender, the petitioner had no notice about the same. And it was only on the basis of an information divulged under the Right to Information Act 2005, the petitioner could come to learn about the issuance of the notice inviting tender dated 5/5/2025. The petitioner also came to learn that on 7/7/2025, the private respondent was settled with the said fishery at rupees 1,70,000 for the purpose of catching fish to be conducted on payment of annual rent. And that too, when the said private respondent number 6 did not participate in the earlier tender process. On the ground, under such circumstances, the petitioner being aggrieved by the actions on the part of the respondent authorities in cancelling the earlier tender process by corrigendum dated 2/5/2025, as well as initiation of a fresh tender process, that too not publishing in the manner in which it ought to have been published, and thereupon settling the said fishery in favor of the respondent number 6 at a rate much lower than the rate quoted by the petitioner, have approached this court by filing the present petition. The record reveals that this court, by an order dated 11/8/2025, issued notice However, no interim order was passed on the said date. Be that as it may, said date, with an observation that this court may consider passing of interim order after the stand of the respondents is brought on record. Pursuant thereto, this court, by an order dated 18/11/2025, taking into account the materials placed before this court by the Standing Council of the BTC, and finding that there was no wide publication, that the notice inviting tender dated 5/5/2025 was not widely circulated, stayed the settlement made in favor of the respondent number 6 till today. So today, Mr. A.K. Bhuiya, the senior standing counsel of the BTC, appeared and placed before this court an instruction dated 22/11/2025. A perusal of the instruction the said instructions are kept on record and marked with the letter X. A perusal of the said instructions revealed that in respect to the fishery in question, that is Helakoba group of fisheries, the highest bidder had put in question, comma, pursuant to the notice inviting tender dated 27/3/2025, 27 or 24? 24, na? 24, 27/3/2025, bracketed hooks, 24/3/2025, SIC dot bracket close. It was opened on 24/4/2025, and the highest bid value obtained was rupees 7,10,000, and the lowest bid value was rupees 1,60,000. It was further mentioned that out of the petitioner was the fourth highest bidder. It was further mentioned that taking into account the comparative statement, the BTC authority were of the opinion that the highest bid amount was influenced by some other motive. Considering the same, the corrigendum dated 2/5/2025 was issued, thereby cancelling the said tender process and going ahead with a fresh tender process. It was further mentioned that the BTC authorities requested the concerned department to publish the notice inviting tender dated 5/5/2025, at least in one Assamese newspaper, daily newspaper, and one Boro daily newspaper. But it was published only in one Boro daily newspaper, that is HAYENNIRADAB. And pursuant thereto, only 3 bidders participated. And the respondent number 6, having been found to be the highest bidder, the settlement of the fishery was made in favor of the respondent number 5. Take respondent number 6. This could also have taken note of the comparative statement enclosed to the instructions in respect to the this court have heard the learned counsels appearing on, this court have also taken note of the comparative statement enclosed to the instructions so placed by the learned senior standing counsel of the BTC. It surprises this court that when the government value was fixed at rupees 1,70,000, only the respondent number 6 had quoted rupees 1,70,000, whereas the other 2 bidders had quoted less than that. Footstop. This court, on the basis of the materials placed before this court, the learned counsels appearing on behalf of the parties were duly heard, who addressed who made submissions in tune with the materials on record, that is the materials on record. Pusto. Materials on record as already referred to here in above. The question therefore arises before this court is as to whether the impugn, whether any interference is called for in the present facts and circumstances of the instant case to the settlement made in favor of the respondent number 6. From the instructions which have been placed before this court by the learned senior standing counsel of the BTC, it appears that pursuant to the notice inviting tender dated 24/3/2025, as many as 8 bidders had participated. For the settlement of the fishery in question, seeking settlement of the fishery in question. Out of the said bids so submitted, two bids were submitted which were above 6 lakhs. Three bids were in the range of rupees 2 lakhs to 2,50,000. And two bids were 1,70,000 and below. The materials on record further show that the previous settlement value was rupees 1,70,000. The decision on the part of the respondent authorities to cancel, taking into account that the highest bidder had quoted an exorbitant rate cannot be faulted, as well as cannot also be looked into in the proceedings wherein the petitioner is not the highest bidder, but rather the 4th highest bidder. Under such circumstances, this court therefore is not inclined to interfere with the corrigendum published on 2/5/2025, thereby cancelling the tender process initiated by the notice inviting tender dated 24/3/2025. The next aspect which arises is as to whether this court should interfere with the notice inviting the tender process initiated by the notice inviting tender dated 5/5/2025. It is the very stand of the respondent authorities that they wanted wider participation, and therefore they had requested the authorities concerned to publish the notice inviting tender in two newspapers, that is one in Assamese and the other in the Boro language. However, it surprises this court that without the publication being carried out in the Assamese language, Assamese daily, why on the basis of a publication only carried out in the Boro language paper, the respondent authorities proceeded with the tender process. The said aspect, therefore, the said aspect smacks of unfairness and lack of transparency. Further to that, it is also this court further to that, it is also surprising to note that in the notice inviting tender dated 5/5/2025, it was categorically mentioned that the tender value of the fishery in question was rupees 1,70,000 with enhancement of revenue of 10% per month. The effect on the lack of proper circulation of the notice inviting tender is reflected in the comparative statement, wherein the respondent number 6 had quoted 1,70,000 and the other two bidders who participated quoted less than even less than the tender value. The said, therefore, do not show that there has been it's a case of transparency and fairness demonstrated by the respondent authorities in conducting the settlement of the fishery in question. More so, when the basic idea of tenders of present kind is to get the highest to get the best revenue for the benefit of the state. Considering the above, this court therefore disposes of the instant writ petition with the following observations and directions. Number one, this court is not interfering with the cancellation of the notice inviting tender of the tender process initiated by the notice inviting tender dated 24/3/2025 by the corrigendum dated 2/5/2025. Number two, this court interferes with the notice inviting tender dated 5/5/2025 as well as the consequential actions on the part of the BTC authorities to settle the fishery in question, that is 6/75 Bhelakoba Group Fisheries of Kokrajhar district in favor of the respondent number 6 by the order dated, what is the order? 7/7/2025. Full. Number 3. Liberty is given to the respondent authorities to take recourse to fresh tender process by giving wide circulation, and if the respondent authorities is of the opinion that there is a requirement of inserting a maximum viable rate, the same also be incorporated in the tender in question, which is as per the settled principles of law.
Yes, we have both.
What is this additional affidavit?
What's that correct?
This matter is getting longer and longer unnecessarily. Huh,
Let's see, good question. I got to take a look. I got that pointed out. Is the provision in the ARC electricity supply code. When it comes to the assessment of certainly the period of assessment. 7.4.21C says wherever there are electronic meters are installed and the load curves are studied periodically. The period of unauthorized use of electricity to be limited to the exact period as to be determined scientifically.
MDI.
Electronic, yes. Now, that's why that this provision,
He said about the, if I remember correctly, he said about this provision, this should be there. Then you said that it is not required because at that point of time, that provision was not there when it was at that point of time. Then I said that there is this is a insertion, it's a case of substitution. And therefore I asked you, what was substituted? And this is now we are today.
Madam, there are two provisions, madam. This provision was existing at the time of inspection, madam.
No, that is what you said. He also said.
No, madam.
as far as this
This
provision that are
provision is
better.
there,
Now let us open the file to see what it is, if I'm not wrong. His submission is here, na, 24/7/2025 order. Let us see that order. The petitioner and so and so has assailed the order dated demand passed in appeal, whereby the appeal so filed was partly allowed and partly has also challenged the demands so made by biller. From the materials on record and the findings of facts which have been arrived at by the learned appellate, it appears that pursuant to an inspection being carried out on Iman, it was found that the petitioner had a sanctioned load of 635 kilowatt, but there was excess unauthorized connected load of so and so. Therefore, as per the inspection report, the excess unauthorized load was so and so. It is further pertinent to take note of that in terms with the inspection report, 169 kilowatt of this excess unauthorized load was found in the factory premises of the petitioner and 253 was found outside the factory premises up for irrigation purpose. It further transpires from the order dated so and so passed by the ER that there was a direction to make a fresh assessment on the unauthorized use of electricity by ER on the quantum of the excess of 422.64 kilowatt for a period of 12 months at double the tariff prevailing at the respective period. This is as per 5.4.3.
Just with regard to, this under the 2017.
Okay, 2017. The learned counsel appearing on behalf of the submitted that the petitioner's establishment was connected to a MDI meter. The manner in which the assessment is required to be carried out is 7.2. The learned counsel drew the attention of this area to so and so as well as so and so. However, the assessment which has been made is not in accordance with the said. Mr. So and so that submit that he would require certain instructions in view of the submission so made by the learned counsel for a year. Then you took. Then the next day came up wherein it said he obtained the instruction as per the instructions so also could not have been applied taking into account that assessment is of the year 2018 and there was an amendment being made to the regulation of 2017 by so and so which was notified on 3/1/2019. This court have duly taken note of the notification dated demand and from clause 4 of the amending regulation, it transpired that clause 7.4.2 Roman 3 of the regulation was substituted. The word substituted has been used. This court inquired with Mr. B. Goswami Chaudhary as to what was the concerned regulation which was substituted by the amendment made in the year 2000 given effect to so and so. Then you take time, then it comes. Upon perusal, it appears that clause 7.4.213 of the regulation was in existence prior to the amending regulation. And taking into account that the assessment in question was of the year so and so, this court therefore taking into account the specific stand of the petitioner that the meter in question was elected inquired with Mr. B. Chaudhary. Counsel again sought for 2 days time. has submitted, he has got additional pleadings to file taking into account the queries made. And you did not file any additional pleadings,
So I did
or you filed 2811.
27.
Okay, 2811, let us see that. We have boiled down the aspect to a smaller question. It's now we are in a micro level.
If I don't have it, takes up the additional affidavit.
On 2811,
Yes, madam.
yes,
There are three onwards, madam.
was in existence prior to the amendment of the regulation A. However, in the case of unauthorized extension of load, prior to amendment, two basic parameters required for computation of the assessment charges are the sanctioned authorized load as per agreement and the total detected load found during inspection. The sanction authority is reflected in the model agreement. In the instant case, the sanction load was 635 kilowatts. The total connected load or total installed capacity of the consumer, on the other hand, can only be ascertained by physical inspection and taking note of each load separately and thereafter calculating the load. It is imperative to mention that there is no other way to ascertaining the total installed capacity of the other than by carrying out a physical survey. So, what you do, as I understand, in layman's language, sanction load is there,
Yes.
which is as per the agreement. Now, when it comes to seeing that what is the physical connected load, you will look into those switches.
All the appliances. or
What do you mean?
equipment.
Let us go on a more simpler.
Yes.
We are laymen, you are me. Just for example, those switches which are there, they will be some you take it at 10 watts, 15 watts, something. And that particular socket out there, you will take it at 150. Then if you did a bigger socket, you will take as per what is 1,500 or 2,500. If you have an AC, which is 2 ton, you will put it at 2,000 kilowatt. You'll put it down there. So this is how, by making physical, you have to find out. While making out the physical, you found 1038 or whatever you found it, that it is excess to this. Okay. Now this is what I have understood from 3. Now 4 is the common meter reading instrument so and so is essential for determining the load curve so and so. So the AI, however, provides no assistance to the appraiser to determine the total installed capacity. Unauthorized uses as the load curves can be kept within the sanctioned load curves by the consumer by scheduling the uses. As such, load curves or other data as available in the CMR, although useful in determining various important parameters required for calculating the actual consumption than in many other types of practice, but the same are inadequate in case pertaining to unauthorized extension of load as the total installed capacity of the CMR. It is submitted that there are various types of unauthorized uses of electricity under there are various instances in cases of excess. Unauthorized means if excess load over the sanction. In the case of unauthorized excess, I have to evaluate the two basic parameters. Which is the sanction is total. The sanction not so then another reason. You are repeating the same.
Yes, but the certain instances are quoted, madam. Now,
What
we
is it?
will again.
In case of misuse of power, change of category, we are not concerned with the
Yes,
change
we
of
are- we will
category.
be limited, madam.
In case of resale of electricity, we are not concerned. We are only concerned with
Yes.
extent beyond the power, beyond the authorized load. So the authorized load is 636, he had 11. Now therefore, that particular provision 7.4.2. What is that? 7.
4.2, 1C.
Assessment of charges. The assessment for unauthorized excess connected load shall be made at a rate twice of the applicable tariff in accordance with the provisions of IMAN, excluding the amount of bill swells is found indulging in more than one act of unauthorized use of electricity. The charges payable in respect to such wells shall be used separately. So this is 7.4.2 Roman 2. Isn't it?
I'm on 1C.
Huh?
I'm on 1C, 7.4.2, 1C.
1.
1C.
What? What is this? This is 2017.
2007.
That is what I am reading.
Yes.
1.
C.
1C.
7.4.2 1C,
Yes.
where electronic meters are installed and the load curves are studied periodically. The period of unauthorized use of electricity could be limited to the exact period as could be determined scientifically. Now they say that it cannot be determined scientifically. Then how do you say that 1C will apply?
Yes, madam.
You tell me how are you going to find out? Because this is going to solve a lot of problems with the tea and the coffee industry. I'm taking up another matter on next Tuesday. Huh? Tuesday, actually, Tuesday night. Like last day, on one hand, Mr. Vallabh Bhumik was there, and the other is Mr. KP Bhatta.
Sanjeev T.
That was prior to. This is prior to the 2016, but the same issue.
Sanjeev T. company.
Something. I don't see the names of the parties. I only know the lawyers. Here in this case, I know Mr. M. Soike and you are. In that case, they were there. But it was a case of tea industry that I know. Now, what happens? This has a important connotation. What he is saying. You say that 1C cannot apply, taking into account you cannot look into it scientifically or have an assessment. Because this has a lot of impact, like more particularly this is also what industry is this? This is also tea, the same tea. So there also, these are seasonal. Earlier, in his case, it was 6 months thing. 1.5 times, and you have to look into last 6 months earlier. Now this was amended in the year 2016, 16-17 or something. It was amended in 2016-17, whereby now it has been made 2 times 12 months.
Yes.
Isn't it?
Yes.
And my contention is that matter, how they will use the metering system matter. That is matter, generally, the connected load is not under the explanation of unauthorized use of electricity. That is considered by the Supreme Court as unauthorized use of electricity when it consumes. Consumption is there, matter. That is matter, I have submitted judgment matter.
Sitaram.
Sitaram matter, para 87 last week matter.
Era?
87 last. Here matter is pointed out matter. Having dealt with
The
and
cases of excess load consumption, then the connected load inter alia would fall under explanation B6 of section A, besides it being in violation to 82 and 18 of the regulation and the terms of the agreement. What is B6? Electricity. Very complicated issues you are bringing. This one, this is Sanjeev T.
Yes, but it's listed today.
Oh, it is there. Where is that, Mr. KB Pathak? Let us hear together all the matters. What is this? Everybody will come piecemeal. I'll pass one judgment. The other person is going to again pass again judgment.
Item 20.
Item 20. That is?
Listed today.
We'll take up this at 2. We'll hear both of all the parties together. This is, I can't hear it piecemeal again, the same thing. Only difference out there is prior. Because there also, Mr. Bhumik's submission is that, look, here, it cannot be done. But he was not clear. I was of the opinion that unless you challenge that particular provision, which gives it. Now, the question is, if it is an MDI meter, but 1C will only come when it can be done scientifically. And your specific statement is that you are not in a position unless you carry out on day-to-day basis.
Now, my lord,
But tell me, in your electronic meter, you can find out what is the connected load at a particular point of time just by pressing the meter. There's no quarrel with that
Yes.
proposal.
But it cannot be connected.
But you don't have the curve maintained from there.
Maximum demand is there.
Huh?
Maximum.
No, it's not maximum also. Just for example, you go to any meter, the electronic meter, they have that particular switch, not the switch. This is how you get what is the
Yes.
consumption. You can just put it out there. You can see what is the actual charges going on, how much units have been consumed, as well as also see as to what is the present connected load. Present connected load by just putting it.
That is correct.
That is, you can find it. And therefore, that point you can very well find it.
But directly measure connected to is not unauthorized.
Huh?
Directly measure connected to is not unauthorized. When consumption is there, then only it comes measure.
No, understood. But
If consumption is there, then it records.
let us see one. We'll have it at 2. Not.
if I just point out one thing, my lord,
Yes.
what we perhaps are looking slight on this, because 1C is under the provision of period of assessment. For ascertaining the period of assessment, 1C can be taken. The APDCL can take reports to 1C.
Which one see here?
7.4.2,
Ah.
1C,
Ah.
the one that he is referring to.
If it is scientifically possible.
Yes, it is only.
Where electronic meters are installed and the load curves are studied periodically.
If my lord reads above that, is for a period of assessment. Now so basically to ascertain the period of assessment, when it comes to unauthorized usage or theft of
Reaches to the
electricity or-
conclusion unauthorized use of electricity had taken place in keeping with the, no, with just 1 minute. Here he has referred to the judgment now 126.
I also refer to that.
You, both of you are taking my time, huh? Because this is otherwise meant for the other councils. Because you are again going to repeat the same.
Yes. That could-
Okay, 126, he is referring to one clause. 126,
126,
explanation B6. Where is explanation B6?
Explanation 4.
Or B4? For the purpose other than for use of unauthorized area, for the purpose other than for which the use of the area was authorized. So why are you saying the cases of excess load consumption, then the connected load inter-area would fall under the so and so, besides it being in violation here? So if you consume more than the authorized load, it would come under unauthorized.
Is consume matter. And if I consume.
Oh. Mr. Counsel, you are reading it like a statute.
Reason behind,
No, this is the way of expression.
no matter.
2 o'clock?
Matter considering.
Both your
that
cases.
Matter, reason behind it that they're giving excess load matter.
No. Enough.
I
Enough.
would also rely. on-
There's too much for this court also. I need to immediately dismiss your petition so that you can take up that issue before the division bench, and the division bench also dismisses luck. And then you can take it up before this, or the division bench can, otherwise I am not. এইখিনি ভৰাই ল'ব দেই, এইটো 2টা বজাত ল'ব লাগে। Don't spoil my time. Oh, your matter. What about the other matter?
6.51.
Okay, we have it on 5-1. You file, get anything out there? Any additional affidavit filed? Why?
It's not required.
Huh?
It's not required. We have already filed.
We put that question. Inquired as regards the procedure to be followed for the purpose of increase in the fee and whether the state government has framed rules in terms with so and so.
But I- action मतलब and फिर मतलब some मतलब जाना है
Oh, madam, I have asked you some instructions you have not given. We take action. We take action. You have sent a letter, they are not giving any importance. We ask the Director of Municipal Administration to be present in the video. Huh? Yes. Heard Mr. D. Chakraborty, the learned counsel appearing on behalf of the petitioners. Mr. S. Dutta, the learned senior counsel, assisted by Mr. S. Dutta, the learned counsel for the respondent Silchar Municipal Board, now Silchar Municipal Corporation. I've also heard Ms. Udas, the learned additional senior government advocate, who appeared on behalf of the Director of Municipal Administration. This court, by an order dated 4/11/2025, categorically sought for an instruction as to whether any rules have been framed for the purpose of stipulating the procedure for levying of fee, and further whether mere publication of the draft proposal of the annual budget estimate can be construed to be a notice in terms with section 68(1) of the Act of 1956. Ms. Udas, the learned additional senior government advocate, submits that instructions were sought from the Director of Municipal Administration by the communication dated 14/11/2025. However, till date, the Director of Municipal Administration have not reverted back. It appears that the Director of Municipal Administration do not wish to take the benefit of the services of the additional senior government of the services of the councils, the government councils. However, as the said aspect is very relevant for a proper adjudication of the instant matter, this court therefore directs the Director of Municipal Administration to be present before the court through a video conferencing link at 10:30 a.m. on
5-1.
Thursday,
That matter was.
on 5/1/2026. It is, however, observed that in the circumstance the instructions are provided, the presence of the Director of Municipal Administration would not be required.
That petition and number, should I mention that other case, petition number?
It is on 5/1.
That is also.
You can make that submission also. Then we can give another date also.
because of yoga in this maybe on 7 or 8 because some
No, it can't be because the other matter is on 5/1. That is I said, that is what I said. This order may enable you to get the instruction. Are you telling me their office is closed?
because of
You just send him the order as well as the video.
I think the six.
Yes, what is this? Oh, this one.
Yes.
I think we should finish it up.
2025, passed an order from para 7 to 12 text.
Yes, what is your stand?
Really, the
Who are you?
time for explanation.
We'll hear you. His case is that, look here, he was selected prior to the respondents being selected. His select list was prior in time to that of the select list of the respondent number 6, or respondent authority. And as such, his seniority position should be ahead of that of the respondents. That's your case.
Lordship comes to page 207 of your lordship. This is the 23-10-24 selection board meeting. Last paragraph. In regard of.
Which paragraph? Which agenda?
This is
207, na?
Computer typing.
Huh? You see, the problem is, it's 207 is the minutes of the recruitment board selection meeting held of the establishment in the district and session judge Baksa Musalpur held on 23-10-2024. This is the first page. Which paragraph?
Last paragraph.
It is unanimously resolved.
Yes.
Yes.
Strike out the marks obtained in the.
Where? This strikeout is not here. You are referring to some other page.
Page 107, Mr. Lord.
Okay, now therefore, my number is different. It is 209. Okay. Read it. For post of computer typist,
Yes.
Josna Musari, Pulok Dekha, Gunojit Das. Okay, then
Board has unanimously decided. to
in this
strike
regard,
out the
after threadbare discussion among the board members, I carefully for proper justification to the employees and for the interest of taking a concrete, the board has unanimously decided to strike out the marks obtained in viva voce test for the LDA come typist and so and so in skill test for computer typist from the total marks they got. Thus, the final position of the employee on merit on so and so is which Kapil Das go there. Okay. Kapil Das is given 74 out of 80. Dharminder Das 59. This Kolita 59. Total number of percentage in written test. Dharminder Das 59. Okay. Then it is seen from the table A that the total marks obtained by the employee namely test the so and so are the same. In this circumstance, there is 3. So in the 3 of the record of the high court shall be to note who is senior in the age shall be considered as senior. To determine the seniority in the age of so and so, we counted on the basis of their date of birth. And that does is at the top and so. Yes, now
That is the reason she was for that matter.
okay, so you held it together. After holding it together, then you thought it that you should have the entire selection on the basis of the written test.
Yes.
And forego the others,
Yes.
that is the practical test. Taking into account that for the purpose of a typist, the parameters cannot be equated with that of a stenographer. Who are those people? Or a computer typist cannot be with an LDA. So that cannot be done. So under such circumstances, you took out the practical aspect out.
Yeah.
And thereupon, on the basis of the seniority, you had that particular thing done, and then there were 3 persons who have got 59. So their seniority was taken on the basis of their age.
That is,
So it is nothing to do with seniority, first select list, second select.
that is as it emerges from the field.
What do you say? He cannot say anything more.
Well, apart from that, my lord, so the selection procedure are two different, my lord. On date of appointment, the respondent and the petitioner is the same. So then category C will come from the notification of the.
No, understood. All these things I understood, but this is done as per the select list.
Fine, yeah.
How will that, though other things comes in? Because they did it as per that. The way categorical DC, the 3 persons got 59. So because of the 59, you have given them therefore, yeah, but 5, 6 and 7 were adjusted with 100. Why? Madam, kindly come to page 207 and 208. Why 5, 6 and 7? Who are these 5, 6 and 7? Your client? Losna Musari? Yes.
Yes, that's a petition.
Why they are being adjusted with 100 and the others are 80?
Find it here in rank list.
It gives me an imagination why a test match people score slowly. 50 overs, 300 plus runs considered to be good, 350 good. And the rate is around 6. It's considered to be good. But when it comes to 2020, rate below 8 is not considered to be good. So here also, it is easier for a person to get 59 out of 80. But to get the same percentage of marks, that is 74 out of 100, would be different. How do you take care of that issue? In fact, this was earlier somebody argued on this. I was taking up. How do you take care of that issue? That you can have everybody at 80. It's a different thing. But you are not doing it at 80 for everybody. Only for those computer typists, you are putting it at 80, removing out 20. And for others, the LDA, you are putting it at 100. How do you do together? This is the biggest problem we are facing in view of the
Yes.
draft rules not being made. Problem with that is the main
This
issue.
is the draft.
Because you cannot equate, they may belong to the same cadre, but you cannot have a same selection. Isn't it?
Then my lord,
Draft rules. Rule 20C takes care of this situation also.
Rule 20,
1C.
Of the draft rules.
Draft rules.
no, draft rules is no rules. Draft rules is not, that rule has gone for a 6 again. No longer that rule is there. Even after the finance has approved, it has gone for a 6. Those are gone. Now, another set of draft rules are coming.
a lot of matters.
Eh?
Lot of matters pending, but it is not.
Yes, all these matters, most of the High Court matters are pending only for that. Others are almost done. We are concerned with this. Here again, how do you reconcile that, madam? You have to give me an idea to give a judgment in your favor, dismiss his case. Because they have been evaluated with 100 marks, whereas these people have been evaluated with 80 marks.
What, it is 108.
Huh?
180.
Yes.
What?
For the petitioner, it is written
It's 100.
100. And for the respondent is 80.
80. So therefore,
Then
writing 80 is easier.
defies reason, Madam. Defies reason.
How do you equate them? Or is it a proper classification to group them together?
Yeah.
This is the most important aspect.
Notification itself.
That is the thing, Doctor. They may form separate classes also. Because one of the judgment, the apex court says that persons coming in earlier selection process and subsequent selection cannot be evaluated together.
Now, that is another aspect. But here they are to be treated differently. First, you don't want to give them that marks. If you had done it with these, taking into account that people have got so and so. Now, why did this particular person, Josna Musari, get 110? It was done out of how many marks? Huh?
80.
No. 173.
No, how did she get 110?
Maybe 100, maybe 150 because it's 73 plus 37.
It can't be 150 because only 73 is being taken up. There the problem again another. Kapil Das, who otherwise secured 79.5 by taking into account the other aspects. Now, his percentage was much below. If you take with 100, that is around 79.5. Now, removing it and putting it under 80, his percentage now goes to 92.5. Not properly explained. Fellow, let us wait for some time. Let's see how the draft will set up. Is there a stay? Oh, I'll pass the stay now. Because what the argument on the basis of which I stated then is not for the reason they have employed. Have you filed a reply?
That is that they are also, they are not questioning this mark.
No,
The petition.
reply was not filed on time. I was on, but reply was barred by this court
Obviously, but I cannot take.
for our fault.
Oh. So if that is not an issue, you have not challenged this procedure. Your procedure is on another thing. So on that basis, we should dismiss it.
Or a single word whisper.
We should dismiss it.
Oh, sorry, but
No, you see, your case before the court was what? Then look here, you were selected in an earlier select list, and they were selected in a separate select list. Your select list was prior in time, and their select list is subsequent, though appointed on the same day. So therefore, you have a seniority. That's your case. They say, no, that is not the reason what we have done. Our reason is we have employed a particular method. We are doing it at 80 out of 79 out of 80, out of 80 for some, and out of 100 or 150 against somebody. And this is how we have obtained these marks. So your entire basis of your case goes. You are not challenging that procedure.
From that.
So we dismiss it, right?
Anyways,
one more High Court matter is gone. Huh?
Colour is
District
sex colour.
what is so?
Sex colour.
We dismiss it now. Good. Let me come back. 10 minutes we'll dismiss it. No. We dismiss
Lots
it.
of they're striking out of marking.
Think about what to say after 10 minutes. That is, I give you a thing, then I'll dismiss it. Yes, how do you take care of it? Without a pleading, challenging this type of action, how do you take care of it?
What will allow us to say seven, plotting a favor order.
Can by way of a reply, you extend what is not there. By way of a reply or an additional affidavit, whatever you can do, you can improve your case. But can you bring in something new which is never there?
What is these minutes of missing are also annexed in the repetition also.
Understood, but that is, if it is annexed, then how? Why you are not challenging on that? Have you challenged it then?
Yes.
If you have not challenged it, wouldn't that the law be applicable? That if you are to challenge, you have to challenge the entire thing. If you don't do it, having a, you cannot raise something else. How can this court otherwise take into account those aspects? Tomorrow, if I pass a judgment in your favor, wouldn't that judgment be impugned only on the basis that this is not a part of the case of the petitioner? How do you take care of it? By way of an affidavit, you cannot. You may have to withdraw,
And highly possibility.
or what is the status? What stay did I grant you?
Lordship stay in the final relation. Stay on
It's a
the
gradation list, na?
regulation.
You can withdraw and file a fresh.
Yes.
I think that is a better option.
Yes.
Because then you need to do that. Because tomorrow you have if it was a case where some promotion is required to be granted, then obviously you may go for an amendment. Otherwise, the interim order will no longer be there. So I think the best way is for you to withdraw in view of the stand and file a fresh one on the basis that there was no classification. There couldn't have been a reasonable classification or at all a classification in a manner envisaged under Article 14, taking into account that they have grouped totally different groups which cannot be grouped together.
Yes, yes.
You have a good case, but a good case is not a part of your pleadings.
But today I told my clients that this is the demerit, that is challenge that.
So you do one thing, you withdraw it with the liberty to file a
Yes.
fresh one in view of their stand. I think that is do it quickly.
Yes.
Next,
Immediately I will.
next Thursday, I take it up.
Yes.
Okay?
Yes.
Mr. BP Bora, heard Mr. BP Bora, the learned counsel appearing on behalf of the petitioner, Ms. S. Sharma, the learned standing counsel of the Guwahati High Court, and Mr. A.K. Hussain, the learned counsel who represents the private respondents.
This one, no, but only seven. Only seven.
Private.
Huh?
Right. This one is number 7.
Isn't he a private respondent?
Private response.
I had the respondents. Other are there also.
Private respondent.
Other private respondents.
Mr. BP Bora, the learned counsel appearing on behalf of the petitioner, submits that taking into account the stand which have been taken by the respondent authorities in putting the petitioner below the private respondent in the gradation list is required to be challenged as there is no reasonable classification. He further submits that by way of an affidavit in reply or an additional affidavit, he cannot improve the said aspect in the present proceedings. Additionally, if he seeks an amendment, it would only prolong the proceedings. He therefore submitted that without prejudice to his rights and claims made, the rights and claims of the petitioners in the present petition, the petitioner may be given the liberty, petitioners may be granted the liberty to withdraw the instant writ petition and refile. This court have also perused the stand which have been taken by the respondent authorities And it is also the opinion of this court that if the petitioner has to succeed, necessary pleadings are required challenging the stand. Under such circumstances, this court therefore allows the petitioners to withdraw the instant writ petition with the liberty to refile without prejudice. Interim orders passed earlier stands vacated.
There the petition claims that petition is along with the interim order. And along with the communication and extra time.
Yes, what is your stand, Mr. Bushra?
Why?
The Guwahati High Court at the time of appointing had put the petitioner at serial number 2.
One.
One or two? One or two? One. In the initial selection,
He was one.
he was one. And the private respondent at 2. And there was a direction by the Guwahati High Court to appoint, to pass the appointment order to the MSCD. That person concerned issues him the first letter, appointment letter, and not him or her, whatever it is. And the resultant effect is the first appointment is here, he is senior to him. Isn't it a violation of Article 14? That's your case. Huh?
They confused by going through the notification dated 14/10/2020.
Page.
Page 42. But
No, this is okay. There's no quarrel with that, but there is no quarrel with that. An employee who has joined the service earlier shall be placed above those who have joined later. There is no quarrel. But the fact remains that you have deprived the petitioner of the opportunity by issuing the year later. Now, if we see the rules concerned, a person is entitled to join within 15 days. If he joins within 15 days, but the fact remains his appointment is subsequent. One day after, the petition, the respondent number so and so was given 1 day prior the appointment letter and he joined. Then the petitioner was given the appointment letter and he on that day or the next day. Now, isn't that wrong? So therefore, what is required to be done by this court is have to say that declare that the appointment of the petitioner has to be construed to have been done on the same date on which the private respondent was done, and taking into account the provision which is say that within 15 days one has joined it. So therefore, the petitioner has to be senior.
only thing is, while your lordship was dictating the judgment, then the private respondent number 7 was not a party to the request. Then only
Yes. Earlier counsel who was representing the petitioner was not clever enough. Now she's clever. She has found out the mistake and done the needful. See,
private respondent did not take care.
obviously, the reason is very specific. You are there for private respondent. Yes. Huh? Who is there?
Change for the respondent number 5.
Who is there?
Repeat
The private respondent.
the respondent was in Kanekya.
Huh? What about the other one?
pilot service has been completed, he has not appeared.
What is your stand, madam? You are appearing for response number 5. What is your stand? What? Who is your senior? J Pang. There he comes running. What do you have to submit?
Sir, sort of, schedule.
You are paying for response number 5.
Yes, sir.
When was your date of appointment? Huh?
The appointment was issued on 34/12/19, and training was on second of May 2020.
No, this is the gradation list. Lecture 11.
Yes.
Response number 5 is date of appointment is 2/5/2019. Isn't it? Who is Navajyoti Bora is response number 6. His appointment is also 2/5/2019. And yours is
3/5.
3/5/2019. Okay. No, the problem is not with, where's the select list? Yeah. Ah. 5, 6, E. Petitioner was appointed was here. Number 2 was Lipika Rani, that is 5. Number 2 in the select list, 1 and 3. Now, the High Court have directed the member MACT to appoint so and so.
Yes.
And in pursuance thereto, petitioner was appointed on 3/5.
Yes.
And he joined on 3/5. Whereas the respondent was appointed when? 2/5.
Yes. Right, understand.
And
Joined on 2/5.
because they were appointed on 2/5. So therefore, we have to deem that the appointment letter of the response petitioner shall also be on 2/5. Otherwise, there is an unfairness committed by the MACT tribunal. Isn't it? What do you say?
That is one aspect. Another aspect, what if the this were with common select list. There was a common select list for the natural district. They were not given choice when they were to join. These were, this High Court, its own most of them. They have prepared this list.
Huh?
This High Court has prepared this list, without asking their choice where they are want to join, because this was a district selection. And they-
No, Mr. You kindly see this document. Kindly see annexure 4, page 44. So the High Court specifically directed the member MACT
Yes, but that is.
that these are the 3 names. You therefore issue the appointment letters.
That is true, but
Now this person concerned, the MACT member MACT, what he does, he gives the appointment to the response number 5 and 6 on 2/5 and to the petitioner on 3/5.
what my instruction is, madam. When they visited madam on second, after getting this madam notification, they went on second, only madam respondents went on second, they were appointed on the appointment letter issued on then. As the madam the petitioner visited on third, he was appointed, his appointment was issued on third. That is the thing. Otherwise, they did not go on second. That's why. they
But
have-
Mr. Payang, you are such an expert in service law, so I'm asking you one question. Is appointment orders to be passed on, issued on the basis of when the person visits? Or is it on the basis of the direction given by the High Court for the MACD member, MACD to issue it? Therefore, you have that particular provision in that year. This is done under the Assam, which rule is this? Under what act?
Assam Judicial Department, Assam District and Session Service Establishment.
Assam, yeah. So there, if we see rule 6 or 11, what is that? I forgot. I forgot Assam, no?
Recruitment.
Recruitment.
Groups, Transfer Code. Rule,
No, not that thing.
Here, one.
12.1, yes, 12.1. 12.1 says, in the lower division cadre, the seniority shall be according to the date of appointment. If the person joins the appointment within 15 days of the receipt of the order provided in case of a person prevented from joining by circumstances of public nature or for reasons beyond his control, the appointing authority may extend it to a further period of 15 days. If the period is not extended, his seniority shall be determined in accordance with the date of joining. When, however, more than one persons are appointed on the same date, the intercessors shall be determined according to their position in the merit list prepared by the district as mentioned in the note below. So and so and so and so. So it should have been on the same date,
Appointment should have the same date, madam.
and they joined on the same date. Petitioner also, if he could have joined within 15 days, then also he would have maintained the seniority.
That's my limited understanding also, madam.
That is also my limited understanding. So let us put this in black and white now.
One aspect, madam, we should also be considered that base 25,
Page
25. Madam, this is the madam district log off. What is?
yes.
Madam, as per this, madam. There were 9 persons in the unreserved category.
Then also you can't have still a march taking into account the person whom you are appearing is at serial number 4
Yes.
and the petitioner is at serial number 3.
That is, madam. But my contention was, madam, the establishment which were allotted to the either to the petitioner or some other respondents. No social event to us, madam. This establishment, when selecting this establishment, we are not given any chance where we will join or we are not given a prior information that we will be given to this systems. Now, on the basis, madam, this honorable court, by publishing this result, madam, they prepared this, madam, this on the basis of their own. This is not our choice. Now, madam, some persons was below me, who are even below me. They got some other, madam, suppose to do the next step, serial number 5. He got posted at secret school. Now, she can say, madam, she has a mother promotional aspect. Now, as I have been appointed as the MSc, the duty mother respondent, the petitioner. So I have no more prospect of promotion. I have no more prospect of promotion because there is no more 25-6 posts. But the mother, below than me, below me, serial number 5, Nilab Nayan Deka, she was even in but she will have the prospect to promote to the upper in future. So that aspect was not considered well. That is the only my mother remarks at this. Otherwise, I have no because admittedly, my lord.
Mr. Payal, I always take up matters on Thursday, High Court. You are most welcome to come on the other side by filing a petition. not in this way. Enough. I think we should dictate. No more time spent. Heard Miss So-and-so, the Learned Counsel appearing on behalf of the petitioner, Mr. G. Boisho appears on behalf of the respondent number. Miss Yuda Asaburu appears on behalf of the respondent number 1. Mr. G. Boisho appears on behalf of the respondent number 2, 3, and 4. Mr. J. Payang appears for the respondent number 5. None appears on behalf of the respondent number 6 in spite of service having been affected upon the respondent number 6. The petitioner is aggrieved in the present proceedings by the gradation list of the staff for the year 2024 issued a gradation list of the staff for the year 2024 in the office of the Motor Accidents Claims Tribunal, Nagaon. And it is under such circumstances, the said gradation list has been put to challenge. The brief facts of the instant case, as it appear from the materials on record, is that an advertisement was issued on 13/11/2018 for filling up by the Register Administration come in charge Centralized Recruitment, Guwahati High Court, for filling up of various posts of LDA/copyist/typist in the District Judiciary of Assam. The number of posts were duly mentioned in the said advertisement against each district. For the purpose of the present case, it is relevant to take note of that in respect to Nagaon district, there were 12 posts which were to be filled, out of which 9 posts were reserved for unreserved category, were kept for, out of which 1 post each were reserved for STP, STH, OBC/MOBC, and the remaining 9 posts were for unreserved category. The said, pursuant to the said selection proceedings so initiated, a select list was published by the Guwahati High Court through the Register Administration come in charge Centralized Recruitment, Guwahati High Court, for the district of Nagaon. In the said select list, the petitioner was at serial number 3 and had secured 91 marks. The respondent number 5 was at serial number 4, having secured 90 marks. And the respondent number 6 was at serial number 8, having secured 89 marks. Pursuant thereto, a select list was published on 30/9/2019 by the Guwahati High Court, by the Centralized Recruitment Centralized recruitment. Centralized recruitment. Guwahati High Court. By a notification dated 30/3/2019 for the district of Nagaon, the petitioner was put as serial number 3. The respondent number 5 was put at serial number 4. And the respondent number 6 was put at serial number 8. And they were also given a posting in the Motor Accidents Claims Tribunal, Nagaon. Pursuant to this notification dated 30/3/2019, the Registry Administration come in charge, centralized recruitment, issued a communication dated 24/2019, intimating the member Motor Accidents Claims Tribunal, Nagaon, to issue the appointment letters to the selected candidates in its establishment. And after issuing appointment letters, initiate police verification process and other necessary formalities. The contents of this communication, dated 24/2019, is relevant for the purpose of deciding the instant dispute. And as such, the said communication, dated 24/2019, is reproduced hereunder, Annexure 4, page 44. It so happened that the learned member, Motor Accidents Claims Tribunal, Nagaon, who is the respondent number 4, issued the respondent number 5 and 6 appointment letters on 2/5/2019. And the petitioner, who was higher, whose position was higher on merit, in the merit list, in the select list, as well as in the communication dated 24/2019, was issued the appointment letter on 3/5/2019. The materials on record further show that the respondent numbers 5 and 6 joined on 2/5/2019 itself. Upon receipt of the appointment letter, both dated 2/5/2019, whereas the petitioner joined on 3/5/2019, having received the appointment letter on 3/5/19. Thereupon, the records further reveal that both the respondent, petitioner, as well as the private respondents continued to render the services in their respective capacity in the Motor Accidents Claims Tribunal, Nagaon. In the year 2024, pursuant to a notification dated 16/9/2024, the gradation list of the staff of the year 2024 of the Office of the Motor Accidents Claim Tribunal, Nagaon, was published. The petitioner was surprised to learn that the petitioner was put at serial number 6, whereas the respondent number 5 and 6 were put at serial number 4 and 5 respectively. Being aggrieved, the present petition. This court, by an order dated 7/3/2025, issued notice thereby directing the respondents to bring on record their stand by filing their affidavits. The record reveals that the respondent number 2 and 3 had filed their affidavit in opposition. Wherein the stand so taken is reflected in paragraph number 5 of the said affidavit in opposition. It was mentioned that pursuant to the communication dated 24/2019, which have already been quoted herein above, the contents of which have been quoted herein above, and bracketed. The respondent number 5 presented herself for appointment on 30/4/2019 and was issued an appointment letter on 2/5/2019. On the other hand, the petitioner was presented himself for appointment on 3/5/2019, and accordingly, the appointment letter was issued to the petitioner on 3/5/2019. It was further mentioned that as the respondent number 5 joined the establishment of the Member Motor Accidents Claims Tribunal, Nagaon, before the petitioner, hence the respondent number 5 was placed above the petitioner in terms with the said notification. It was also mentioned that the gradation list dated 24/10/2024 was published pursuant to the notification dated 16/9/2024 issued by the government, redesignating the posts of the staff of the subordinate judiciary. To the said affidavit in opposition, the official respondents have enclosed the appointment letter of the respondent number 5 dated 30/4/2019. It was 25 nowadays. Respondent number 5 was issued on 34. 25 The petitioner, the appointment letter of the respondent number 5 dated 30/4/2019. The appointment letter of the petitioner dated 3/5/2019, as well as the joining letters of the respondent number 5 dated 2/5/2019. It was also mentioned that there was a provisional gradation list prepared in the year 2023, wherein also the petitioner was placed at serial number 5, whereas the respondent number 4, 5 and 6 were placed at serial number 3 and 4. Further to that, it was mentioned that the respondent number 5 and 6 were put ahead of the petitioner in the gradation list in view of the notification dated 14/10/2020 issued by the Guwahati High Court through the Register Administration come in charge centralized recruitment. An affidavit in reply has been filed by the petitioner. Retreating the stand which have been taken in the writ petition. And further questioning the aspect as to whether there is a requirement of the candidate to appear before the authority without any notice for being issued the appointment letter. This court heard the learned counsels appearing on behalf in the backdrop of the above pleadings, this court heard the learned counsels appearing on behalf of the parties whose submissions were on the basis of the pleadings as above noted. Analysis and determination. Before dealing with the facts, this court finds it relevant to take note of this court, during the course of the hearing, inquired with Mr. G. Boishua, the learned standing counsel appearing on behalf of the Guwahati High Court, and what would be the rules applicable insofar as the appointment of the petitioners, as well as the respondents. The learned counsel submitted that the relevant rules could be the Assam District and Session Judges Establishment Ministerial Service Rules 1987. Taking into account the above, this court therefore, before dealing with the facts, before analyzing the facts above noted, would deal with some of the provisions of the rules of 1987. Rule 6 refers to recruitment to various posts coming within the ambit of the service as defined in section Rule 210 of the rules of 1987. As this court is dealing with the question of seniority, it is relevant to take note of Rule 12, and more particularly, Rules 12, Sub-Rule Roman 1, more particularly Clause 1 of Rule 12, Roman 1 of Rule 12, which is reproduced hereunder. From a perusal of the above quoted, Sub-Rule 1, Clause 1 of Rule 12 of the Rules of 1987, it is seen that in the lower division cadre, the seniority shall be according to the date of the appointment, provided the person joins the appointment within 15 days of the receipt of the order of appointment. It further stipulates that in circumstances of a public nature or reasons beyond the control, if the person cannot join within the initial period of 15 days, the said period may be extended for a further period of 15 days. However, beyond the initial period of 30 days, if a person joins pursuant to an appointment order, his appointment would be taken as the date, his seniority would be reckoned on the basis of his date of joining. It is also very pertinent to take note of that when more than one persons are appointed on the same date, their inter se seniority shall be determined according to their position in the merit list prepared by the district and session judge as mentioned in note of clause A of sub-rule 5 of rule 6 of the rules of 1987. This aspect is of relevance, taking into account the dispute involved herein. In the backdrop of the above, now let this court analyze the facts. From a perusal of the materials on record, it is clear that in respect to the district of Nagaon, the petitioner's position was higher than that of the respondent number 5 and 6, inasmuch as the petitioner had secured 91 marks out of 115, whereas the respondent number 5 and 6 obtained 90 and 89 out of 115 respectively. In the select list which was published by the notification dated 30/3/2019, the petitioner was put as serial number 3, whereas the respondent number 5 and 6 were at serial number 4 and 8. And the petitioner as well as the respondent number 5 and 6 were assigned their posting in the Motor Excellence Claims Tribunal, Nagaon. The communication dated 24/2019, as quoted here in above, categorically directed the learned member Motor Accidents Claims Tribunal, Nagaon, to issue the appointment letter stating inter alia the position of the petitioner vis-a-vis the respondent number 5 and 6. It shocks and surprises this court that the respondent number 4, who is the learned member, who is the member Motor Accidents Claims Tribunal, instead of issuing the letter of appointment in terms with the directions issued by the Guwahati High Court, by the communication dated 24/2019, issued the appointment letter on the basis of when the candidates, that is the petitioner, as well as the respondent number 5 and 6, appeared before the said authority. This act on the part of the respondent number 4 is unknown in service jurisprudence. The resultant effect of the actions on the part of the respondent number 4 is that the petitioner could join only on 3/5/2019, whereas the respondent number 5 and 6 could join on 2/5/2019, and thereby moving ahead in the seniority. The question therefore arises as to whether such a course of action is permissible. In the opinion of this court, the answer is an emphatic no, taking into account that it was the duty on the part of the learned member of the member Motor Accidents Claims Tribunal, that is the respondent number 4, to have issued the appointment letter of the petitioner, as well as the respondent number 5 and 6, either on the same day or the petitioner's appointment letters in the same day, and under no circumstances the petitioner's letters would have been issued pursuant to the on a later date than that of the respondent number 5 and 6. This action on the part of the respondent authorities, more particularly the respondent number 4, have resulted in violation of the mandate of Article 14 of the Constitution, in as much as the respondent number 4 failed to take action in accordance with the directions issued by the Guwahati High Court on the administrative side, as also have acted unreasonably and unfairly against the petitioner. The next next question therefore arises as to what directions can be passed in the facts of the instant case, taking into account Rule 12(1) of the rules from 1987, which have been already quoted here in above. It is the opinion of this court that taking into account that the respondent number 5 and 6 have joined on 2/5/2019, their appointment orders cannot be pushed one day later, that is on 3/5/2019. However, it is also the opinion of this court that the appointment letter of the petitioner, which is dated 3/5/2019, can be permitted to be read as being issued on 2/5/2019. And further, taking into account that the petitioner have joined on 3/5/2019, in terms with clause 1, Roman 1 of Rule 12 of the rules of 1987, the petitioner can maintain a seniority ahead of the respondent number 5 and 6. Accordingly, the instant petition therefore stands disposed of with the following observations and directions. The gradation lists so published of the Motor Accidents Claims Tribunal for the year 2024 is interfered with to the extent that the petitioner first, the appointment letter of the petitioner issued on 3/5/2019 be read as dated 2/5/2019. Number 2, the petitioner having joined on 3/5/2019, that is within a period of 15 days from the date of his appointment order, would maintain the seniority, would be senior to that of the respondent number 5 and 6. In view of the position of the petitioner vis-a-vis the respondent number 5 and 6 in the merit list as well as in the select list. Number 3, the impugned gradation list of the staff of the Motor Accidents Claims Tribunal for the year 2024 is interfered with, thereby directing the concerned respondent authorities to publish a fresh gradation list, putting the petitioner ahead of the respondent number 5 and 6 in the same gradation list. Anything more you want?
Here, third line, minority, here, the reference to the 5 has been.
Next, sir.
Next, line, page 51,
It's 50. What is this?
Here, the name of the reference number 5 has been recommended for conversion of UTA in case of senior communication.
In view of the above directions and observations and directions, the learned member, the member Motor Accidents Claims Tribunal, Nagaon, shall revisit its recommendation so made to the Joint LR and Joint Secretary to the Government of Assam dated 22/8/2024, inasmuch as the petitioner would be senior to that of the respondent number 5 and respondent number 6. Anything more? There shall be no order as to cost. The said, this court further directs the respondent number 4 to carry out the above exercise within a period of 15 days from the date a certified copy of the instant order is on the judgment is within a period of 15 days. You intimate.
Timing, 1917.
You are there. You are appearing for that respondent number 4. I would have understood government is okay, but these are under you. Yes, who is there? Mr. Somua. You don't look like Mr. Somua. Yes, tell me. What? Okay, you are appearing. Now tell me. He wants some document, there was some glitch. So he wants to submit that document. Let him be allowed to submit if it is not possible technically, because the last date is tomorrow. If it is not possible on your part to accept it on digitally or by uploading, then accept it by hand if it is. 2 o'clock, get your instructions. 2 o'clock instructions, because we can't have it tomorrow, because tomorrow it becomes difficult. Mr. Counsel, you have to understand, this copy of this order, the petition was given to you on 2/12/2024. Anyways, ask your boss, can you do so? You have read the petition or not? Have you read the petition or not? Then you must have understood what is the contents of the petition. Seek an instruction as to whether you would be accepting if there is any technical glitch. If there is no technical glitch, we have it tomorrow. But if there is technical glitch, just ask them whether there is any technical glitch. We'll have it at 2.
Same similar question. That if they ask for all the documents of the other person, then just point out one thing.
No, that is not there. I need it by 2 o'clock.
If I can bring it about it, there is an agreement in my family, my maternal uncle is expired. So I want to take a lawsuit permission to go for the funeral. One of my colleagues will be here. If a lawsuit raises any query, he will answer.
Timing item 17, take that to first.
Move on to sort.
Half an hour break. Half an hour break.
You get the instruction after half an hour. Who is presently running the?
Nobody is done. May I just show one paragraph of the these. Normally in this kind of situation. I know that
What is this?
only in the chair manner, if some documents which cannot be entered, then there is a provision for showing. 48 hours they get. After they get.
This is a commercial document of what?
This I did not get, I could not find out, but one activity I found, in GM portal, I will just, this is the activity given by the. There they have shown that as per GM. There is a provision for providing, there is a window. So can I kindly see that case is also people who are big more than 2,000. But particular mark. Affidavit filed by the opposite party must. Knowing that they give us. Next page of article find out. It is applicable to all persons.
This affidavit is filed by whom? Union of India. How does this have any relevance?
Because same gen of function. But if somebody cannot find a proof from the document, they will tax. They supply it with their votes. If they follow that, I will find out. That's all happening. Normally they will say whether gen you can do. That I can do, except my hard copy.
Now we may ask them to extend the period.
But now I cannot open. I cannot open, after putting one document, my lord, I cannot enter any other thing at any period. And after 26, 27, we have uploaded. Then this EMD. And thereafter, my lord, I am not in a position to upload any. It stopped talking. Wait.
I think we bring back to PM.
What is what's your case?
What has happened, the APDC, total scheme of EDS scheme, voluntary demand scheme. My lord, scheme, my lord, will find at page number. Thirty.
Yes.
Very. My lord, this is a voluntary declaration of road scheme that was brought up by APDC, where it's stated. That
But Mr. Sharma, you wait for some time. I'm in the midst of hearing another matter, na? Which matter could go? Item number 20 and item number 7. I'm in the midst of hearing that matter. We'll hear you later. Because again, to start a new matter while I'm in the midst of another electricity matter. We may take the help of Mr. Kejriwal in that matter also. Don't worry, I'll take it up. But you see, I'm already taking up another electricity matter. There are not one, there are two matters. One is by Mr. M. Sokia. And the other is by, who is appearing for the other side? Mr. Pallab Bhumik was there, he has left, but there is somebody else who is going to appear on it. Yes, Mr. Sokia. What do you say in your reply? Let's see. Your submission is, as it appears, is no doubt there is an excess. But this excess is found on the basis of connected load. On the basis of the connected load. And if it is in excess, but it has to be seen as to whether while carrying out the connected load, which is in excess, whether there was consumption beyond the sanction.
Yes, sir.
That's your submission.
Yes.
But does the regulation provide that?
I
If the regulation stipulates that if it is in excess of the contracted load or the sanction load, then it shall be deemed that you are using in excess of the it is an unauthorized use of electricity.
Yes.
Then in that regard, you have to pay this. This is the manner in which it is to be calculated.
Yes.
Now, you therefore say that 7.4.1c says about the method of assessment. So the method of assessment is if there is a curve maintained and scientifically proven, then in that regard, it has to be adopted that manner. But my question is, if they don't have that facility, which they say in their affidavit, that it is not possible to get it because the meter concern does not show at all points of time. At the time of inspection, they looked into various connected loads. But there was a possibility, taking into account the meter, the electronic meter, to find out as to what was the connected load at that relevant point of time. That is possible. But you didn't look into that aspect.
The meter data, the electronic data.
You may not, it may be. The fact that you may not look into many other aspects. You may not be, but from the very meter, one thing is particular, that on the date of the inspection, you did not look into that very aspect, which was you could have looked into and found out what was the load. Or can you presume on the basis of the connected load?
The my response to that would be that it would only reflect the sanction load or the contracted load. It would also reflect the units consumed, the load curves, like how I've explained in my additional affidavit. As far as the additional load is concerned or the unauthorized part is concerned, meter is not equipped to show that.
Are you sure? I'm sure to make that statement.
The affidavit,
No, affidavit is okay, but I'm asking you, can you say that when a person uses, just for example, in this particular room, that total load is 5 kilowatts, and we put a meter out there, you cannot find out that it is using 7 or 9 or 10? That meter is not permissible?
those are my instructions.
No, that cannot be so, because as I from here know, isn't it, Mr. Kejriwal? That is what I am asking you, that we require his presence. Because as I've seen,
It's the post 7.4.2. The Roman 3A.
there is MDA
It is
meter.
provided that all the electronic meter must have the MD reading. MD reading is the maximum demand recorded by the consumer in respect of the electricity consumed by him. So whether he has exceeded the load or not, that will be reflected in the meter, in all meters, electronic meters. Because in two parts, really. One is demand charge, and the second one is unit charge. Demand charge is based on the maximum demand recorded in the meter. If the contracted demand exceeds, in this the consumer is liable for payment over overload payment. That is why this is deleted from the panel provision in subsequent amendment below. If the consumer is equipped with the MD meter, in that case, there cannot be any penalty for unauthorized use of electricity. Because mirror, under section 126 also, it is the unauthorized user. It is the excess user which is made penalty. Not the extension of load simplicity. Your lordship has the occasion deal with this issue with the iron. And your lordship has remanded the matter to the authority to find out, because this being a judicial issue, to find out whether if the meter has to record maximum demand. In that case, there cannot be any question of consumer exceeding any excess.
Therefore, this is the particular provision. If I'm not wrong, earlier I had dealt with this aspect somewhere. Kindly come to this one, 7.4.1, 7.4.2, Roman 3AB.
Yeah. This is the provision.
Yes, madam. That
In
provision-
case of connection with MDI meter, in case of connection equipped with MDI meter, no assessment shall be made for unauthorized extension over and above the connected load as per the agreement. Penalty for drawal in excess of contracted demand shall be levied at 3 times the normal tariff or the portion of the demand exceeding the contract demand.
That is the position as on like 2019. The assessment here is of 2018, prior to the amendment,
So this provision was not there.
not there. This amendment was brought in on 11 January 2019.
What was the provision earlier?
But the methodology remains the same. I will pass the relevant.
Another problem.
This was the 19.
Wait, let me speak. There's another one. 11.1.
That actually, that is my, that is literally what?
7.4.2. This is the one at that point of time, which was valid. So they didn't have that. Assessment of demand charge and energy charge for unauthorized use of electricity shall be demand charge in case of excess here. Excess demand charge is equals to 2 into C into B into N minus D. A denotes the authorized load as per agreement. Where is A in that? A, I think this is, no? Yes, yes. B denotes the connected load detected at the time of inspection. B. C, demand charge applicable on the detected load as per tariff in the force. C. Number of months duly taken into account of fraction of a month. What do you mean by that? Number of months duly taken means? Number of months duly taking account of fraction of a month means?
What is your order? Has exceeded, and rather than using, considering the whole of the month or
Another fraction because the demand charge charges in a month, the recycle is 1 month. That's right.
fraction of a month, perhaps we could, rather than considering the whole of the month or not considering the month at all. The actual number of days for which the unauthorized use of premises can be determined, and that should be considered.
How that can be done, determined?
If it can be, that somebody has exceeded the sanction load, for example,
If it cannot be determined, then it will be zero.
then it will be either 12 months. Then it will be 12.
How do you so?
As per section 126.
Huh?
As per section 126, that formula will come in. If the actual period cannot be the yes, then it will become 12. Then the relevant portion would be 7.4.2, Roman 1, the proviso to clause D, proviso to clause D.
Provided to,
Clause D of Roman 1.
if the period during which unauthorized has taken place cannot be ascertained, as such period shall be limited to a period of 12 months immediately preceding the date of inspection. So it will be into 12. Then demand charge, if any, paid for the disputed period on A. So then minus. And then how do you, where is it mentioned, denotes the total connected load detected? How do you ascertain the connected load detected? Is it on the basis of meter or is it on the basis of whatever may be? Because here it says where electronic meters are installed and load curves are studied periodically. The period of unauthorized use of electricity could be limited to the exact period as could be determined scientifically. Based on valid document produced by the accused person, the period from the date of inspection, if any, by the license officer to the date of detection. But how do you assess the connected load?
Otherwise, it is defined here. So it is defined under
Where?
At clause 22, 1.4.122. The page number 6.
4.1. Expressed in kilowatt means the aggregate of the manufacturer's rated capacity of all energy consuming devices or apparatus connected with the distribution license in the consumer premises, which can be simultaneously used and shall be determined as per the procedure laid down in the code. If the rating is in kVA, the same shall be converted to kW by multiplying the kVA by a power factor of Imam. If the same or any other apparatus is rated by the manufacturer in HP, the HP shall be converted in cents. So it will be in the consumer's premises which can be simultaneously used and shall be determined as per the procedure laid down in the code. So there is some other procedure.
And normally, physical load and inspection, which has been done in this case also.
No, in this case, it is, where is the physical load inspection
Yes, sir.
procedure?
Seven point 4.1 C.
1,
C.
4.1, 4.1C. Shall prepare a road report giving details such as connected loads, procedure for booking a case, condition of seal, so and so. So this will be done in terms with the physical inspection.
When he detects that unauthorized load, they can check it case. then he has to prepare a report where he has to fill in these queries.
In the consumer premises which can be simultaneously used, means to be used at once,
Yes. That one.
and shall be determined as per the procedure laid down in the code, means it will be done as per a physical verification.
What it basically means.
So therefore,
Was the usage of the term connected load and not sanction load. That is important. But the sanction load is different.
and there is no problem with the sanction load. Sanction load is there in the agreement.
Yes, the connected load is important, the usage of that term, because it could also, within under its field, also take into account the unauthorized.
Obviously, the difference between the connected load and the sanction load, if it is found in the positive, then obviously it will be that is the unauthorized use. Then you are going to multiply the connected load or the detected load into the denotes the total connected load detected at the time, denotes the charge. So the C is the charge into connected load into the number of period. If there is no period, then 12 months minus D, which is the 12 months period, how much they have paid, and then multiply it by 2. Okay.
Which has been done in this.
Now tell me another thing, another very interesting aspect. Denotes demand charge applicable number of months duly taking account of the fraction of a month, N. Now you say, therefore, you will have it at 12. Here it says, if the period during which such unauthorized area has taken place cannot be asserted as above, such period shall be limited to a period of 12 months immediately preceding the date of inspection. So the word is such period shall be limited to a period of 12 months. But it doesn't say that the period will be 12 months. Meaning thereby, it can go up to 12 months. If it is so, then you have to give a justification why. Because you see, if you are having it by 12, but you could have also to 1 month, or even to a fraction of a month, making it 15 days, if you can have it. Because here you use this number of months duly taking into account of a fraction of a month. And then minus it, but because you are otherwise multiplying it by 12 too. If you are multiplying it by 2, obviously the difference will keep on going. Then what is the justification that you have put it at 12 months and not anything below that? Yes, please, both of you. Therefore, I gave you.
Perhaps what this will entail in option is, for example, in a hypothetical situation, it is more than 12 months, say it is 13 months, 2 years, but we cannot assert it the period. Even then it will be limited to 12.
But then also N denotes number of months, means it can be less than 12 months.
Can
Also.
be
Duly taking into account of a fraction of a month.
Fraction of a month.
So therefore, if it can be below 12 months,
It can be below 12 months,
but
provided.
what steps have you taken to find out it can be below 12 months? Because this is a very important aspect, because otherwise the amount goes very high.
Yes.
Because the difference will be, obviously you are having it twice for 12 months, which could be happening for 1 month also. Or wouldn't it show that you are required to carry out a regular inspection and you could not find out, and here you today, one fine morning after 2 years, 3 years, you carry out an inspection and now you say that, okay, 12 months you pay.
Perhaps this will have a direct bearing section 156, subsection 5.
Let us see that.
Because I think this section has been provision has been incorporated in option. In terms of that.
Let us see. 126.5. if the assessing owner reaches to the conclusion that the unauthorized use of electricity has taken place, the assessment shall be made for the entire period during which such unauthorized use of electricity has taken place. And if, however, the period during which such unauthorized use of electricity has taken place cannot be asserted, such periods shall be limited to a period of 12 months immediately preceding the date of inspection. So therefore, my question is that you cannot assert it. If you cannot assert it, then only it is shall be limited to a period of 12 months if you cannot assert it. But isn't it also a responsibility or a duty upon you to ascertain what is the connected load? More particularly, when these meters in question categorically showed from time to time that you can very well, although the amendment was made in the year 2019, but prior to that also, those meters categorically showed that what was the connected load? When you make an inspection, that's why you see, check out the bill. In that particular bill, you categorically put out there in that bill what is the connected load, everything is there. Have a look at it. You have a copy of the bill. Any bill?
My lord, I have annexed, my lord, in item number.
Normal bill, huh? Not their
Normal bill.
dangerous bills. Yes.
Normal bill, my lord, item number 4. Public number, my lord, that is 80.
We are taking your rose candy or what?
Rose candy, my lord.
Rose candy. I'm giving more importance, taking into account particularly the name of the park. Yes, what is this rose candy bill? Any bill?
That is 80, my lord. And that is 50. Yeah, my lord,
No. Normal bill if you have.
my lord, this is normal bill.
This can't be, you have it in a particular format. Any bill, just find out where any have you been given an issuance of a bill lately?
My lord, this is regular monthly bill.
Can't be a normal type copy like this. There will be much more. This is an earlier one. Is that normal bills? Pursuant to that, they have made an assessment. Nah? Where is that assessment bill?
My lord, that is-
This one, yes.
Yes, my lord, recorded demand, maximum demand.
Yeah, you see what are there? What are the formalities? Yeah, you see the bill number, bill period, bill date, number of days, due date, so and so, gross current, amount in words, gross area, 0, gross so and so, net amount. Then you have installation consumer number, old consumer number, so and so, meter reading, unit, penalty, so and so, billable, so and so. Energy charge, total energy, demand fixed charge, total demand charge, overall penalty, energy charge, electricity duty. Connected load. Yeah. You see, connected load is given out there 412. Contract demand is 485. Just for example. So you have every bill which you are issuing. You have taken note of that because this is a bill when you make an inspection, you don't raise a bill otherwise. A person very well goes to a consumer's residence, checks out there, put these details, and this is then being reflected in the bill.
Perhaps, Your Lordship, what is done while a regular meter reading is that only the number of units are checked. For example,
No. Therefore, you have there. Kindly see this.
this is the connected load, Your Lordship, which was actually authorized to be consumed.
No. The contract demand.
The contract demand in the connected load, Your Lordship. Perhaps if
And the connected load is this, na?
Your Lordship may kindly see.
So you see the contract demand is the sanction load. In this case, which document he is using, contract demand is the sanction load. So here you have 485 is the sanction load.
Sanction.
Now, what is connected on the date of the inspection is 412.
That is what he is authorized to connect. So if your lordship has the next bill, for example, at page number 81,
Yeah.
even there it will be the same, 412. The one after that, when there it is the same. Because this is what we have authorized him to connect. So without what your lordship, the procedure under 7.4C of the actual detection of the connected load of the date unauthorized use is detected, if that is not done, we cannot determine what is the actual connected load. This is on the presumption that yes.
It is your mistake in not putting this.
Mallet, that the middle part table mallet, there, middle mallet, middle of the bill mallet, that table specifically mentioned recorded demand, mallet maximum demand, billing demand.
Ah, reported demand,
In that particular. bill
so and
mallet,
so, maximum demand KVA 502.
Yes,
And what is BD?
billable demand.
Billable demand is 502. Then here it keeps on changing, you see, 496.
Yes, sir.
So and so, this is there.
Yeah, mallet, for
So
maximum
if that
demand.
be so, how do you take care of that?
Connected load and KVA are two different things. Your lordship goes back to your definition of connected load. Connected load is always expressed in KW with the load.
KVA can be changed into by multiplying by 0.85. There's no quarrel with that. But it is changing, you see. So therefore, here, what is RD, MD, and BD?
And this basically means your lordship, the KVA is the number of units he has consumed. The
No. Units is given down there. There is another units. Units current, gross current is here. Amount in words, 8 lakhs, so and so. Their units is different. Units is different. Meter, so and so, previous meter, present meter.
This
See, this is being given. Now, what is RD, MD, and BD?
RD is recorded demand.
Reported
MD is
demand.
maximum
And MD is
maximum demand.
maximum. And
If-
BD,
If I use simultaneously maximum capacity mallet, then recorded demand. And at particular in the bill mallet, the petitioner has consumed more than connected demand mallet, that is 496. Because of that, they have imposed penalty mallet in that particular bill, at page 80.
so this is up post 2019. Oh, no, this is there, 2017.
Relevant period.
So this was done as per the MDI.
Yes, madam. MDM.
These
Now
are
again,
MDA
the
meters.
settlement has been
Ah,
and the
therefore,
double jeopardy has committed.
If you have this system, then why? Because you see, you cannot universally think, okay, we don't do all these things, although we have given you bills from time to time. But we have an opportunity, you have to give an undertaking or give us affidavit that your meter is not capable of finding out the contract demand, the connected demand. Can you give that statement by way of an affidavit? At any given point of time when the inspection is being carried out. You cannot. Because it is there. If that is very much there, then how on earth can you be permitted when you are raising every time the bill not to look into that? It appears that you have not taken or exercised your duty properly when that particular there and not inserting in this particular format. If it was required, you could have very well find out.
Is my question.
It may have been, yes, 1 month, 2 months. In 1 month, you could have very well taken. Therefore, in an MDA meter now after 2019, as Mr. Kejriwal said, you cannot go beyond that.
now, the scope now is very limited.
That is why the amendment was brought in to make it more clarificatory out there. But the question is, when it says it cannot, has to be asserted and cannot go beyond it. And more particularly when N says the number of months. So it may also be 6 months also, 2 months also, 3 months also.
Even the definition of meter also speak about unauthorized use meter. Definition of meter says meter means an equipment used for measuring indicating and recording electrical quantities like energy in kilowatt or kVA, maximum demand in kilowatt or kVA, reactive energy in kVAR hours, etc., including accessories like current transformer, voltage transformer, potential transformer, capacitor voltage transformer, etc., were used in conjunction with transmitter, which shall also include any seal or sealing arrangement and other measures provided by licensee for sealing reliability and for preventing theft unauthorized use of electricity.
Mr. Pathak, can you give an affidavit that at a given point of time when you carry out the inspection every time, because obviously you will have the person very well goes for the purpose of inspection for getting the meter reading. At the time when his inspection was carried out, the meter did not provide the avenue to find out the connected load. That would be the period of inspection. This law would have been very well permissible in a normal case where you had the other meter, the manual meter and all that, which just spirals out there. But can you find out that? Can you say that? Because this aspect will have far-reaching ramifications. Because as I could see, in all cases, you deem it that it is 12 months. But from my personal experience, as I could see from a meter, I've seen it, it permits you to get what is the connected load being used today immediately. You can just press and find it out that what is the point, what is the units, how many units is going on, what is the connected load, what is being used now. Sometimes it may be 3 kV, 6 kV, 7 kV, and all these things will be there. And the kVA is being put out there, only they don't, in the meter, they don't put it at kW.
Yes, it's
It is in kVA. So this kVA has to be multiplied by 0.85, and then you get the kW. So there is no quarrel that on the day on which, but can you take it on the basis of that connected load basis? By everything when you had that. Yes, I'm only on the basis that without going into that there is a year, but can you have it for the entire month or 12 months? It can be 1 month also.
In that way, they have considered for assessment method, I have been. But they have not done, because they are claiming 1057 kW has been counting through a 750 kVA meter. How can it be possible? Because connected load is as per definition simultaneously used by that and divide. But if I counting in that way, then the second.
And therefore I'm saying it further mentions simultaneously used and the mode by which it is to be, the procedure mentioned in the regulation as to how it is to be calculated.
Yes.
It cannot be on the basis of physical verification cannot be said to be a method, the procedure. The procedure has to be something else.
So even in this bill, there is an overdraw penalty.
Understood?
So
There is
if
no
an
quarrel.
overdraw penalty has been levied, so that means they have done some exercise to determine what is the amount of consumption of electricity
I admit
beyond the
that.
sanction.
No quarrel, no quarrel. I'm not on that. But can you directly apply 12 months?
Yes.
What I'm saying.
If it cannot be asserted, means where is the justification that it could have been asserted? That is a very important aspect. After all, these are consumer rights.
Based on the actually extortion right matter. But when they have not proper.
Let us not go into that.
Yes, that is correct.
That is beyond the files.
Another I am saying because they are visited They've go yesterday for taking snap of the connection method of using the AD as a part of the method.
Now, in the case of theft also, it's a different aspect because there is, you can very well have it. Because you may not know exactly when this has happened. It becomes very difficult. But when it is a case of connected load, where you have there is no allegation of theft, like by Mr. Pathak in the other case, it's a different aspect. It's a case of theft.
Tampering.
So when it's a case of finding foreign materials, it would not come within this.
Yes.
But in this case of another excess load, then it is a different aspect. His case is an excess load, your case, and his case is temporary. And if the tempering, the theft is not proved, then under 135(5), the special tribunal will judge and then minus it. Then it may be whatever may be how it is to be done. But here we have a problem. You have to give us why it could not be asserted.
You know, it was possible to assert it firstly, and if it was, why was it done? If it was not done at all.
Huh?
If it was firstly, whether it was possible to assert it by finding out from the meter whether or not the connected load is reflected.
Yes.
If it was reflected, if the assessment was not was carried out without taking that into account. Those two aspects are covered.
Could it be ascertained or could not it be ascertained? Because if in tempering you cannot ascertain.
The lordship has
70?
Yes.
79, huh?
Yes. So what? There has been an overdraw penalty already levied. So they were aware, it appears from the record that
If it's in the record, then how can you assess for 12 months? For that particular period only they should assess. And then that also cannot be done because this is double jeopardy matter. Already penalty has been imposed.
and these bills that we were just going through your lordship, these are the bills which have been revised pursuant to this communications. So what appears your lordship is that some exercise was done, determined and by reference to the instructions. That
So therefore, this is the period, na? Concern page 79 is the period.
Yes.
Now, if you see the period, 1/8/2017 to 31/8/2000, this is the billing period.
Yes.
This billing period already paid an overall penalty of so and so. So they have on excess load,
Yes.
they have already paid.
They have already paid.
So therefore, again from 110, but in the month of September, you did not find anything.
Yes.
Again, for the month of October, you found out. December, you have found out. February, you have found out. So this is what you could assert it.
That is what we could assert.
So if that be so, if that could be the ascertainment, then it could have been calculated in that manner.
Yes.
So this correction needs to be done then. I'm not on that.
Yes.
So this an additional payment which he has made on account of penalty, that would be subtracted because we have already taken for that period, whatever may be. But the fact that he cannot be penalized for 12 months,
12 months. And
when you could assert it,
Assert it.
and you have asserted.
we have a.
I think that is the best way. No? But anyways, I give you an opportunity to find out that because you see, this will have a far-reaching consequences in all other matters. Because they have a regular habit of putting the 12 months. Huh? Why should we look into it in Thursday? Yes, tempering is okay, you can, but anyways, I'll also adjourn it, taking Mr. Pallab Bhumik is not there on account of bereavement, so we'll have it when.
One aspect of the matter, the other matter which I can clarify with the lordship. I sought instructions because the fire was not on record, either in our affidavit or in the report. So perhaps, though it was a case of tampering of meter, they are just, I will get. Perhaps an FIR was not lodged. It is an act of unauthorized interference, which is otherwise covered under 126 as per the explanation. But They've perhaps not lost any. So I'm just having that aspect confirmed, Your Lordship.
FI having not lost lodged, but the findings arrived at by both the tribunal, the assessing officer and AR, says that there was a
Not correct, sir.
tampering. And this tampering led to, for that, this foreign circuit, you hold them that it is a case of unauthorized use. So it is not a case of unauthorized load, excess load. So, but then also you can very well do as per 12 months because you don't know exactly when it has happened.
When it-
And you can't assert it.
we cannot.
So there's no scope of asserting, but here you have a scope of asserting. When otherwise I could have made it CAV today. What is this repetition again?
Well, they are two.
Oh, the second one. So the point boils down to that. We don't go further beyond that, only to this point. That without why they could not assert it. We say that that particular clause the particular clause 7.4.2 3.1 would be applicable. We say it would be applicable. But the question is how did you arrive at 12 months is the question. Huh?
Yes.
And in that regard, whether it was as to whether it could not be asserted on the basis of that meter. What is that electronic meter? Electronic meter is here now somewhere defined. Where is the meter defined? Billing meter or main meter means a meter for accounting and billing of the electricity supplied to the consumer. So from the heard Mr. M. Sakia, the learned counsel appearing on behalf of the petitioner, and Mr. B. Chaudhary, the learned standing counsel of the APDCL. This court have duly taken note of the additional affidavit filed by the APDCL, as well as the reply thereto filed by the petitioner. While hearing the matter, there is no quarrel. Upon hearing the matter, it appears that both parties are in agreement that for the purpose of arriving at the demand charge in case of excess/unauthorized load, the provision of clause 7, regulation 7.2.4.2, Roman 3, numerical 1 would be applicable. Numerical 1 of the Assam Electricity Regulatory Commission Electricity Supply Code Regulation 2017. Taking into account the said, The said provision is reproduced here in under. এই পেজ এখনত পাব 90 আছে দেই এই 1 to দিব এই নোটটো নালাগে we don't consider note. From a perusal of the formula, mentioned for arriving at the assessed demand charge in the case of excess/unauthorized load, it is seen various variables have to be taken into consideration. It includes determination of the total connected load detected at the time of inspection, which has to be multiplied with the tariff in force on the detected load, and further, the same has also to be multiplied with inverted comma number of months comma duly taking account of fraction of a month inverted comma close. This court inquired during the course of the hearing as regards the implication of the numerical n in the said formula, in as much as it connotes the number of months, comma, duly taking into account of the fraction of a month. The learned counsel appearing on behalf of the APDCL, however, submitted that if the unauthorized use of electricity cannot be ascertained, such period shall be limited to a period of 12 months immediately preceding the date of inspection. This aspect can be found in section 126 bracket 5 of the Electricity Act 2003, as well as regulation, the proviso to regulation 7.4.2 Roman 1. Proviso not, as well as in regulation 7.4.2 Roman 1. This court had given an anxious consideration to the section 126 bracket 5 of the Act of 2003, as well as clause regulation 7.2 4.2 Roman 1. And the use of the words therein is that if the period during which the unauthorized use of electricity has taken place cannot be ascertained, cannot be ascertained, then only the period shall be limited to a period of 12 months immediately preceding the day of inspection. it also implies that there has to be also justifiable reasons. There has to be also justifiable reasons. For applying 12 months, which has a direct relation to the period during which such unauthorized use of electricity cannot be asserted. The question therefore arises is as to whether in an electronic meter, is it not possible to assert it electronic meter which have been provided to the petitioner during that relevant point of time? Was it not possible to ascertain the connected load this aspect assumes importance, taking into account the various bills produced before this court in WPC number 4646 of 2024, as well as certain penalty amounts being imposed for certain periods specifically. Which gives an clear indication that every month, while carrying out the inspection for the purpose of taking the meter reading inspection for the purpose of every month, while carrying out the meter reading, there is a scope for ascertaining the connected load and this further appears to have been done, resulting in imposition of penalty upon the petitioner. What is that document? Annexure
We have 15, actually, Annexa 15.
15
Annexa 15.
of 646.
Yes, sir.
That is the penalty, na? Four periods. Na?
Yes.
At annexure 15 of WPC number so and so. This court further finds it also relevant to take note of that the respondent authorities, while making the fresh assessment pursuant to the directions passed by the appellate authority, have not taken into consideration the said aspect. Considering the above, let an affidavit be filed by the respondent authorities in this regard, answering to the queries as stated herein above. The said affidavit be filed on or before 8th of January 2025-26. Lists the matter on 21/2026 for further hearing.
During the reply file, yesterday manner, I have made a mistake, in some figure manner. That is the manner I have put it. That is 3.5 manner. May I correct it manner? I am just.
No. You cannot correct.
You were.
Ah, E2 Diop, 22 Diop. Mr. P. Bhumik, the learned counsel appearing on behalf of the petitioner submits that he had to immediately rush. Submitted that he may be accommodated today, taking into account the bereavement in his family. Accordingly, lists this matter along with so and so Agoric petition on 21/2026.
Standing item 70.
Oh, bid is over. Too late. Bid submission date was last is 29/11.
27 we submitted, sir. 27 is the year.
One party submitted all documents.
One could do it, I could not do it.
No, but you came very late, no?
Now, 27 we filed a representation, then we filed a.
No, you came on 2/12. I can't help you now unless you challenge the decision. You could not submit and all. This can't happen like this.
We have filed two representations.
Representation can't help you. I can't give it to you now because taking into account.
The GEM portal, there are a lot of provisions are there.
Then why haven't you approached the GEM?
GEM, because the GEM is controlled by them only.
No, they don't want to. GEM is not.
They will not.
Direct GEM. Mr. Das, you may be aware of it that the GEM has in the portal categorically mentions that there is one column out there where you can very well put your objection within 4 days. And when you put that objection, they can very well look into it and thereupon do it. That I know.
What I find that from that fee, see the GEM document, shortfall within 48 hours, within 48 hours, 4 into 24. They can call for, whether they are calling for or not, I don't know. That you are not.
Matter is over, Mr. Das. You need to, if you want, you have to withdraw with the liberty to challenge this. What instruction that they are going to give it to somebody. I don't know the name. They have not indicated.
Well, tomorrow is the last day.
They say no, as per the bid submission on 29/11. Let us see.
Page number 13.
This is wrong because auction end date is so and so. Auction start date 29/11. Let us see what is this.
11 and 5 here.
Auction allotment of toilets so and so kindly to ATC so and so. EMD payment date, EMD payment start. EMD payment start 15/11/2025. Finally come to page 38.
38. Twenty-eight, 11/25, last date for submission of game. Was 28, not be completed. In fact, when the he could not submit anything after approving his game.
So,
Therefore, provision that because these provisions is difficult to handle. If they are saying that only one bidder has been found to be valid. But the opening date is on tomorrow. Auction opening today.
auction ends.
They can have, but before that they cannot finalize. How can they finalize before that?
They have not finalized anybody.
Documents are to be submitted before that. Documents, proper documents have to be submitted.
I mean,
before that.
before 28.
If somebody cannot do it, I mean, the person will be this. This is a jam notification.
So take it up with the gem. Take it up with the gem.
They can also do it.
Why? They will not do it. As of now, you have no business with them.
Normally, what happens, shortfall after this, if any shortfall is there, they call for. From all the other bidders, wherever the shortfall are. So it says, after evaluation, shortfall documents, confirmatory documents be required. Shall be sought from the bidder. Request for documents and response shall be in writing. No modification will be made, but I cannot give a document prior to after that. Nothing like in EMD. I cannot give a EMD or data something. This document is applicable to vendor.
Mr. Council, you do one thing. We'll have it tomorrow. No orders, nothing. You just find out one thing. Why do you say 28/11 or 29/11 is the last date? From your bid document and get a copy of that document. You have it?
Document that will be submitted in that profile.
Let me have it.
This is the one that I have accepted, and the rest are the one that rejected. Single.
One extension of bid report, bid submission by 4 days, in case number of bids received is less than 3.
Who is Hemando Das? What's your name? We are concerned with. No, we issue a notice, short notice for tomorrow. You just find out. Monday. No, I haven't seen. Monday. You just find out one thing. Tomorrow. 10:30. Only one thing you find out. As to what is the date, why you are saying 29 is the last date. 29, the auction will start. It is not very clear from the auction notice they have enclosed. Because the submission of the bid, here we say, bid submission, regular bidding access. Actually, if it is a GEM portal, there has to be another document. This can't be like a GEM portal document. Normally, a GEM, you have only enclosed this. The GEM portal also will have another document, which wherein the GEM terms and conditions are mentioned. No, Mr. Das. In the GEM portal, there is always mentioned a GEM. There are various terms. Who is the procuring authority? What is the reason required? All these things are duly mentioned. Any information, insight?
Whether they will follow this or not, that also.
But Mr. Das, you have not given the entire document. There's something is missing here. You produce that tomorrow then. List the matter tomorrow. produce that amount. No, you see, I tell you, you have put it in the GEM portal. When it is in the GEM portal, they give the entire schedule. When it is, what is going to happen, all these things will be given. Who is the procuring authority? How much is the bid value? What are the terms and conditions? What are required to be given? Apart from that, it goes into the ATC. Additional terms and conditions which the procuring authority will have beyond that. So these are the ATC which we are having with him, which is being enclosed. We don't have the GEM portal. When it is there, it is in the format. You must have seen it in many cases. So it is in that format. So there must be something. Because from here it is very difficult to assert it. On one hand, the petitioner himself says that 28/11/2025 is the last date. However, the council says that the last date is 5/12. So what is to be believed then?
As per then portal, if they follow the, what I should upload.
Leave the matter tomorrow.
Come as a portal.
Yes,
What's it,
you are referring to that.
Challenging the impugn order of the officer. Impugn order of the officer. Hello, what has happened is here, the APDC had started a scheme, voluntary declaration of load scheme in 2020. A copy of it is at my lord at page 30. Very well.
Page 30. Page 30.
Yes. For better planning and monitoring of distribution network, it has been decided to survey the load of consumers during April and May 2015. However, as a first step, the consumer have been requested to declare their connected load voluntarily within 31st March 2015. The declared load will be regularized as per following procedure. Copy of the simplified format for declaration of load should be made available to the consumer by the field office. Consumer will submit the forms to the respective subdivision IRCA and the subdivision IRCA should acknowledgement for receipt.
I've understood.
Yes.
You think that a person can very well come up and declare,
Yes,
that look here, we are having an additional load.
yes,
And if that be so, then in that case, you don't take any penal action.
yes.
There might be some increase of the load due to increase or augmentation, alteration of the existing connection is required. That should be immediately informed to the consumer and demand notice would be raised against the consumer as per the rule for the meter load security. So you don't apply this 7.4 and all these business.
Yes. So, Malab, there are two things to be noted here, Malab. There is no particular agreement to be submitted while you're declaring the voluntary load. Only the sanction load which is there. On top of that, there is a simplified format that you have to submit. Now, what happened on 27/3/2015? There was an inspection of the site of the respondent. My lord, that is at page 32, the relevant portion.
Yes.
Now, the sanction load that was found was that 5,000, it was more than 4,500 kilo. Now, after we informed the respondent thereafter on 30th March 2013, 15, submitted an application to the APDCL. That is at page 36 at time copy. 26. We have integrated the cement manufacturing plant so and so. We have sanction connected load of 4,500 kilowatt. We have integrated cement plant. Our all equipment does not run simultaneously. We have standby motors and feeders. The brief of the production process is enclosed and marked as Annexure 1 for your understanding. We have filed voluntary declaration for increase of the connected load on 30th March to the office with connected load of 5750 kilowatt. Further, a team of institution and inspectors are assigned on 27/3/2015 and the time was not available. The report of the team is included in Action 3. So it was only after the inspection that they thought of voluntary taking up the option of voluntary load scheme.
So my lord, before that, if they were using a load which was more than the sanction, they should have applied as per the agreement because they was changing the structure. For that, my lord, I
So
was like,
you informed them that you are going for inspection.
no, we did not. This
Then
was,
how will they know
my lord, the scope. If
that
they-
when they were, you had the window open till 31/3?
Yes, we had, there was a window open, but my lord, it is alteration or change. It is there for reason, because my lord, now the 2004 would come in, 2015 is an application. So my lord, 5.3.
Yeah.
At page 1 to 1 at top. My lord.
Hmm.
Should the consumer any time after the energy has commenced desire to increase the number of size, lights, fans, motor in his premises, or any alter in the position of his wiring therein, notice thereof and need to change the connected load, if any, shall be sent in writing to the licensee. If a result of such proposed extension or alteration, there is possibility of increase in connected load over the sanctioned demand, the consumer shall take steps to submit requisition for additional connected load. Failure to regularize the increase in connected load may result in billing at the penal rates as provided for under the rules, and also result in disconnection of supply after due service. So when the 5.3 applicability was there, and my lord, prima facie by this letter, he has admitted to the fact that he was requiring of more load. So my lord, even though VD voluntary demand scheme was there, what he did, my lord, he submitted an agreement of demand contract, which was not part of the scheme. My lord, that is there at Annex 5, page 39. May I read? On page 38, I would like to read the letter. Madam. This is of 24/4/2015, when it was received. Respected sir, we have integrated cement manufacturing plant with state-of-the-art technology. So and so, we have been sanctioned connected load of 4,500 kilowatt. We are integrated cement plant. Are all the equipments does not run simultaneously. We have standby motors and feeders. The brief of the production process is enclosed and marked as Annexure 1 for your understanding.
Now
We have-
tell me, what is the order?
Yes, my lord. My lord, the order of the ombudsman is that, my lord, after that, what happened? We have charged him as per the fixed rate from 2015 to 2018 onwards, when he was later on when he was sanctioned. So we stated that this was a billing error, and as such, the audit gave an objection that you have not charged him as per the prescribed demand mode, and therefore we gave him an additional bill, a supplementary bill, and that's stating that this was a bona fide mistake on our part, where it has happened, and as such, we charge him with rupees 50 lakh. I know the bill is at page 143. And before that, I'm not actually one meeting. With respect to the above 41. I'm directed to inform you that the Power Department Government of Assam only took 47 days of sanction of load in favor of Purvanchal Cement Limited, and after resubmission of all of relevant documents for sanctioning of load, it is observed by the Accountant General in para 3 that APDCL has suffered a revenue loss of 0.47 crore due to non-billing of the consumer. It is mentioned herein that those so and so, but they could not serve the compensation bill as they were the voluntary declaration load scheme was enforced. In respect, the detailed para-wise comments so and so, you are therefore kind of drop the audit para. Then thereafter at page 142, my lord, with reference to the above, this is to inform you that supplementary bill of 50 lakhs is served due to unrealized fixed charge as pointed out in the compliance audit paragraph relating to power audit, and you are requested to pay the amount in full with due date, and the bill is at thereafter at page 150. My lord, the respondent challenged the bill before the consumer forum, the CGRF. CGRF gave an order in our favor. Then he went in appeal. The appeal order, my lord, went against us, and the impugned order is at, my lord, page 342. The order starts from, and the effective part of the order at conclusion and the award is at page 359. Where the bill in its present form is not recoverable by APDCL, the odd, and therefore the collection of any amount through its bill is suspended indefinitely unless made recoverable through a competent judicial authority. The order of Learned SLRGF on the portion making it obligatory on the part of petitioner to pay the supplementary set aside. No observation is made on the other aspect, but that is the court, however, cannot quickly pause the bill, which is generated as per dictate of the Accountant General Office and not an independently assessed bill. Any ruling of the direction the agent or respondent is outside the purview of this court, unless the Accountant General Office drop the direction of recovery to the audit para, is still standing against the respondent APDCL. The court do not find any willful fault of the office of the APDCL as such supplementary bill was never considered legitimate during the course of the event leading to the additional road sanction. The court finds the action of the officer as well as the government legitimate and proper. The delay of 47 months in the additional road sanction was never part of the legal process. As such, the claim of the petitioner for the amount of rupees.
We are not on that.
Yes, ma'am.
Kindly come directly to page 357.
Yes, ma'am.
Therefore,
Yes, ma'am.
10 lines from the bottom.
Yes, therefore, it is improper to allege the petitioner was involved in any malpractice and was found using an excess unauthorized load over and above the contract load. The inspection carried out in the period of DBL scheme was not proper, as already mentioned, the general manager APDCL through their letter 17/2015, and such there is no scope to issue a penal bill. Now, on the ground of any alleged malpractice, my lord, we have not issued a bill on a malpractice. We have whatever the contract demand of file was there.
The other things are different. What do you say about the last paragraph of the first page of your scheme?
Yes, my lord, but that is the penal action. That says.
No. Tell me.
Yes. After expiry of the scheme of the voluntary, the road survey works should be undertaken in effect from 1/4/2015 and completed again 30.5/2015. The action should be initiated as per rule. However, no penal action are to be taken where consumer dealer their excess connected load within a period of scheme for voluntary declaration of load. The penal action is not allowed to take.
And what are you going to do? Where is that scheme? It's very difficult. Are you exempt? You see, kindly see that particular. Where is that document again?
Page 30.
Page
30.
If due to increase, do you come within the ambit of 5? Apart from that, there is no other way out. You see, it is something like, Mr. Sharma, it is something like an amnesty scheme. Sometimes you have the central government giving amnesty schemes. Then look here, a person concerned, how much gold you have, once you declare, it's okay. You declare it, the gold you have. And after that, if you declare till this point, we are going to charge you at 12% of this. We won't charge you on anything as regards that unauthorized or whatever in the year beyond their capacity, the Prevention of Corruption Act and all. In these type of cases, amnesties, you find somebody saying out there that, look here, my great grandfather had a bucket made out of gold also. These are done. This is an amnesty scheme. Then look here, whatever maybe we give up all these things. Anybody wants to come up and declare a loan, if it is in excess, kindly come up and give it to us. whatever additional things which are required to be paid as per this fine, this will be done. Remaining, there shall be no penal charge or anything to that effect. Now, what you are trying to do is, you are trying to, on the basis of getting this amnesty voluntary declaration, after getting that input, now you are trying to impose upon him some penalty, a penalty of some amount. You are trying to bill him as per that amount. How is it possible? This very much goes against your scheme itself.
There is submission. First, we did the inspection.
Understood.
Just
The first you should not have gone for an inspection also. You should have gone for an inspection on 1st of April. Why on earth did you go on 27/3? During the period when that scheme was open?
I understand.
Then you would have been very well. Under very well you could have come in. But here, how do you come in when you have this particular scheme?
My lord, we just reflect to the way the cavalry responded, try to, and page
I remember then what your submission is of the judgment of the Supreme Court in McDermott. A question was argued before the Supreme Court out there that, look here, if you allow these people will be swindling out a lot of money by applying this law and all the state. Supreme Court says, whatever legal means they can take, they can very well take for the purpose of taking not making payment of the taxes. That's still lookout. Now you gave them a legal mean. Now you gave them a legal means. Then look here, whatever done. It's more like an amnesty. You come over and give us all these details, and then upon, because what the idea behind it is, with this 5,780, which is the scheme, kilo connected, now you are going to, against each connected amount, you are going to get additional amount.
My lord,
That is,
and clause 3, I'll just try to interpret again. From the date of receipt of the declaration. So when was it declared? It was because there's been two declaration on this.
from the date of receipt of the declared load should be treated as connected load.
For billing purpose.
Now, after the, no, you have given this period.
The declared load should be treated as a connected load from the date of receipt of the declaration. Now, my lord, may see his date of his application of connected load regarding.
When no alteration, you gave them an open window
My lord,
within so and so.
My lord, annexure 4 once, my lord.
What annexure 4?
My lord, the date.
That I understand. They gave it on 33.
No, thereafter they have again given an application on 24/4/2015.
No, 24/4 is out of the, we're not on that, but they gave it on 33.
My lord, 33, they gave an application to the area in charge. Now, my lord, my lord, will look at annexure 7, page 105, my lord, once page 105. Why I'm saying that there is an application of 5.3 is there, page 105, my lord. There was an application of additional section load of 367 kilowatt.
This is in 2018. We are not
Yes.
concerned with that.
My lord,
We are only concerned with this particular thing that you are not giving him the benefit of this. Isn't it, Mr.?
What happened in this case? As per the scheme, there is no bar that the consumer declaring its connected load can also declare its connected load, because the booking of load by APDCL is dependent on the load contract demand declared by it. Even the demand charges is recovered on the basis of the contract. What happened, my lord? At the time when we submitted the application for voluntary declaration of load, we also submitted a contract demand agreement as per the format given by. Now, prior to submission of that contract demand agreement, on the existing load, they were recovering fixed charges on 5,294 kg. But after declaration, we wanted to reduce our contract demand as per the provision provided in the supply code as well as in the schedule of trade. Because as per the provision contained in the statutory provision, I can enter into contract demand related option. I can exercise
from 70 to 105% of my connected. I exercise that option to the extent of 72%. So by virtue of the declaration, my contact demand or the fixed charge which can be levied by them was reduced because that has to be recovered on 4,871. But prior to declaration, they were recovering fixed charges on 5,200, 5,294. So they sought clarification from their higher ups. And they found that if the contract demand agreement along with the voluntary declaration load is acted upon, then there will be a loss of revenue for 5 letters. Because I have an their own 4-5 letters. They themselves have written to the audit, their higher up, that if we act on the regulation matter, then the monthly fixed charge will be reduced by 1,16,000. So they didn't exercise the power under the GL. They never acted upon. That is also the finding in the ombudsman judgment. What they have done, subsequently they having found that recovery will be reduced by 1,16,000 per month. They asked the petitioner to submit an application for additional. Accordingly, the petitioner applied for additional load of 367 kilowatt on 25/5/2015. That was processed up to the level of power department because regulation matter cannot be processed to the power department as per their own letter. That has to be regularized at billing office. That was not acted upon. That is why a new application which was submitted for additional load on 25/5/2015 that was processed to power department. In 2018 itself, the power department sanctioned the additional load of 367 kilowatt. Thereafter on 2019, February 2019, the area manager that issued load security bills because if the additional load is to be given, then additional load security is to be taken. They have issued a bill in 2019. We deposited after 3 days, we have deposited the load security. Thereafter, the area manager wrote a letter to the SDO to give release the load. And the load was released on 29/3/2019. The present release for the period from May 2015 to 28/3/2019, when there was neither the load was released nor regularized, no additional load was released in favor of the petitioner, and that was never utilized. So that can there be any bill for any anterior period prior to the date of the allotment of the load? That was the finding because no load was given to us. We have no occasion to use that load. Even during this period, there was another inspection by them in 2018. There also this was found below my existing load, that is below 4,500. Their own document, page number 231. You also can see from page number 231, my load was found at 4,497. That was existing load prior to declaration under PDL scheme of 4,500. That was even below to 4,500. So the load which I have applied under the PDL scheme, they themselves admitted in 4 letters below, even before the consumer forum. That if we acted upon, then our revenue will be. That is their admitted position. What was acted upon? They acted upon the application for additional load. The regulation matter was never taken up by them.
But why did you approach the consumer forum?
Because we are under the provision of if there is any billing dispute, there are 3 forums under the electricity. One is if there is any billing dispute, defect in service, or there is a billing dispute, or there is a deficiency in service, then we can approach the consumer forum constituted under section 4. And if there is any unauthorized usability, then there is a provision for under section 126. And if it is a case of tampering or theft of electricity, then there is a provision for a special code under section 1. These are the 3 forums constituted under the Act. This is neither under section 126, this bill is nor under section 130. So this is the provision for approaching the consumer forum, because this is a consumer dispute within the meaning of section 215 of the Electricity Act as well as under the consumer regulation.
So you went there.
Yes,
Let's see your application.
Your Lordship. Your Lordship, may kindly come to page 93.
of the lead petition.
So as on 30th of March 2015, you were found to have a connected load while inspection on 27/3/2015 to the tune of 5750.
Oh, 5739.
Anyway,
1,239 kilowatt, but I applied for 1,450.
anyway, so you therefore say, requested that kindly give me a connected load or the additional declaration of 5750. So this is one chapter. Thereupon what happened?
Now, along with this application, you also may kindly come to page 94.
Yes. Authorized load,
Connected
excess load.
5750,
Hmm,
authorized load 4,500,
hmm,
excess load 1,250.
yes.
It was according to them, Milord. Because Milord, this inspection was by counting the heads of the machines, Milord.
This is your signature.
Yes, Milord, this was given by. Now you also may kindly come to page 97. 96 is the contract demand agreement that was given by me. 97 is the declaration. Connected load equals to 5750. Contract demand would be 4870. This is permissible as per the applicable norms, Milord. In force in APDCL, Milord. as well
So
as-
you are going to use 72% of 5750.
Yes,
You want a connected sanction of 5750,
50.
but you will be using, as per you, a
4870.
contract demand of 4870.
Yes. This was the contract demand agreement was submitted, Milord, before the authority.
Hmm.
Now you also may kindly see page 50, you also of my IA,
Page
page 50.
yes.
On receipt of this application, the area manager wrote a letter to the chief executive officer, Milord. I have the honor to state that premises of Messrs. Purvanchal Smith was inspected on such so and so and detected total connected load of such and such and authorized load of and excess load of detected is such and such.
So at that point of time, upon finding out that this was a excess load in the inspection on 27/3, they did not carry out to make any provisional assessment. That appears from 31/3.
So
So
they-
therefore, he asks for certain clarification from the chief executive officer.
Yes. Whether the penal bill can be issued and whether two clarification is sought to clarify, whether the penal bill can be issued and whether the load, declared load can be.
No, it is not a penal bill. Kindly see. That is why I'm saying. You see, the penalty is different and a provisional assessment is different. I think he mentions about the provisional assessment. Under such circumstances, the undersigned may be pleased to advise on the matter whether a notice for removal of the load, because if we see that he can very well direct remove this load. This is the mandate of law. And subsequent assessment bill means first the provisional and the final assessment bill is to be served upon the consumer on the matter.
Prior to that meeting,
So
they have also submitted
but
agreement document,
no, that I've read it.
contract to such and such.
No, that I've read it. That is why he is asking.
Now he is asking, as per their notes, Milord, this is letter dated 8/1/15. Contract demand is to be accepted from the date of the receipt of the contract demand agreement by the billing office. Because the agreement by the APTCL may be executed subsequently, but they are making alternate arrangement with other suppliers. Booking is required to be made on the basis of my contract, because they have to purchase from others. So booking is dependent on the contract demand, as well as the bill that will be issued to the consumer is also dependent on the declared contract. So he sought clarification whether this can be given effect from the date of the submission of the contract demand. and penal bill can be issued. Now the reply you wrote to me, find at next page. Third line of the second paragraph. Consumers are given opportunity to regularize their excess connected load without penal action through the aforesaid scheme. However, the process of regularization of excess load should be completed by the billing office within the stipulated time frame as mentioned under chapter 3 of the Electricity Supply Code and related matters regulations such as subject to the technical feasibility of the system condition. Moreover, the regulation should be done as per delegation of power by APDC.
Okay,
There's
no, I've
no
read it.
question of any penal. Now, by virtue of this, the direction was given to regularize within the time frame given in the supply code. The time frame is 197 days. They have to regularize within 97 days, and the regularization matter is to be undertaken by the billing office. There is no requirement to refer my application to the power department. Now you will also kindly see the next. This was still made subject matter of audit objection. The decision which was taken by them your notes may kindly turn to page 67
Page
of IA.
67.
There was an audit objection as to why fixed charges were not levied from the date of the declaration from the petitioner. Now this is the reply given by them. And this your this is a reply in response to a letter dated 4190. Reference your letter number such and such. This is a reply to letter dated 4190
By the area manager.
by the area.
But his ranking is below that of the general manager. Of the general manager,
Yes, Miller.
because here if we see page 52. Page 51. Is by the general manager. Commercial revenue dated so and so of the APDC. Anyways,
This reply is personal to query made by the general manager.
but he says that there is no penalty.
Here in this case, he clarified why the bill as per the declared load was not given, because they will reduce. There was some kind of paragraph. That's the matter as reported in the draft paragraph 3. That APDCL has suffered a loss of rupees 47 crore due to delay in regulation of load of asset. Such and such is not correct. Indeed, APDCL would have suffered loss in terms of fixed charge if the connected load would be regularized from the date of declaration of connected load by the consumer. So, that sir, on such and such, the consumer submitted documents for voluntary load declaration as per notification number such and such. But along with the relevant documents, the consumer also submitted a content demand agreement paper such and such, asking for reduction of content demand from 100% to 72%. In case of ST consumer, the dealing of fixed charge depends on contract demand as declared by the consumer. Contract earlier, the consumer had connected load of 4,500 5,294 kVA and 100% contract demand. Total fixed charge of measure such and such per month was rupees such and such 14 lakhs 56,000. A copy of the bill is here. The consumer on such and such applied for extension of load from 4,500 kilowatt to 5,750 under medial scheme in addition to contract demand agreement of such and such. Meaning that if the same would be incorporated in the energy bill, then fixed charge would have to be realized on 4871 kVA, which would yield realization of fixed charge of rupees, that is rupees 1,60,400 less per month.
So what you did earlier against the connected load of 4,500, you sought for a contract demand higher.
No, 100% of the connected.
No, you had,
Previously 100% of the connected load is equals to 5,290.
KVA.
Yes,
So you asked for the contract load for 5,294 earlier. Now,
70%.
what you asked for is 6,765.
Against that 72%.
In addition to the contract demand agreement of 72%, meaning thereby, so it will be on 4871 KVA.
Yes,
So then it will be 1,16,000 less.
less.
Earlier it was being multiplied by 5294. Okay, understood. Then
Next page, look. For the reasons in advice were shown from such and such. This is the letter dated your lordship, just now I referred to your lordship 31 dated. Regarding the effect of contract demand agreement in billing. And billing was continued as per previous agreement. Therefore, no question of loss suffered by APDCL arises as mentioned in the paragraph such and such.
so as on 2020, you are making an assessment that if it is given effect from the date of declaration made on 30/3/2015, they will be losing a particular amount of rupees 1,16,000
Per month.
per month for the entire period in 2020. And therefore, this is the loss for which you should not give. This is what is the advice given by the area manager. Isn't it?
According to area manager, if the contract demand agreement is given effect from the date of the declaration, then they will lose monthly fixed charge of rupees 1 lakh. And
Then-
then they have to refund for the period from May to 19, which they are asking for.
Then what happened in 2020? Another letter
There
issued
is
by-
another letter. This is in on 24/7. First part is regarding the clarification provided by the agent not to raise any bill. Now, second million last part, in accordance with the clarification issued from CGM's no compensation bill was served to the consumer and the consumer was allowed to apply for extension of load under BDL. They themselves allowed the petitioner to apply for under the BDL. In the next page, various time consumed at various level is given. And in the last paragraph, he admits that sir, this is true that APDCL has lost revenue in terms of fixed charge due to regulation input. Regulation matter was never acted upon. This is due to non-release of sanction of additional load. This should be non-release of additional load because additional load was forwarded to the power department and the power department released the same in 2018. Next,
Now, where is the impugn for which you went to the
your lordship will find that NHR 21
of
IA. NHR 20 page 81. This is the letter forwarding the bill.
so this supplementary bill of 50 lakh?
Yes, madam.
Because supplementary bill, they have used the word because of various judgments passed by the Supreme Court also, saying that there is no limitation.
Limitation is a secondary issue.
No. That is the basis on which they raise this idea of, because the Supreme Court had in one judgment, some What is that? Kedarnath or something? Huh?
Rahmatullah.
Ah, Rahmatullah.
Now the law is clarified by Supreme Court in Cassini.
Huh?
That is the latest judgment in Cassini. It was never seen, but that was followed by our High Court in another case. In page paragraph 131, they have the remedy before the civil court if the amount demanded is barred by limitation, that is 2 years, and subsequent thereafter. But they cannot resort to this power of distance. That is their own
They cannot resort to,
distance.
56 limitation.
resort to?
Disconnection of power.
No, that is the
Yes,
same
my
thing.
lord.
Kalimuddin, that also, that will say, you can resort to taking out the money, how you want, by way of before the civil court or whatever it may be. But you cannot resort to disconnection.
Yes.
So you cannot, non-payment of this would not,
That was a
beyond the limitation.
because that was a supplementary issue raised by them before the forum. The main issue before the forum was as to whether there can be any demand of fixed charges for the period from May 2015 to 28/3/2019 in respect of 367 kilowatt of load, which was released only on 29/3/19. This was this.
And this is apparent from this particular letter. Where is that letter? Yes, this one, page 70. Load released on 29/3/2019.
Yes, sir.
So this is the load have been released on 20. So your case is there. From that period, when you asked for on 30/3/2015 to this period, there was no extension of the load of 367.
Either the load was regularized, nor the additional load was released, nor that was used by the petitioner. And this is evident from page 3 to 31.
Now, how do they calculate at page 21 that said amount?
Page, pardon.
Page 82. How do you calculate on what basis?
Your in fact, that calculation was made.
Connected load is 4867.
That is the load on 367 kilowatt. This was made, calculation was made on 367 kilowatt of load.
How do you know?
That is your load to be find from the next annexure, annexure 22.
Huh?
Coding note is there, you know.
How is that?
Page 84 below.
Page
Page 84 below. This calculation period is given.
81 below. 81.
Page 84. Period is given.
What? Which one?
This
I have a timeline of events.
Your also may kindly see the calculation part is there. Last. Consumer number sentences deal with industrial revenue collection.
Application for regularization on 22nd and again on 25th May, adopting conservative approach. However, audit consider application on May 2010 to work out the date regulation. 270 into 4 into 35 months.
217 to 432.
Plus 17 into 12 months. How do you take 35 months?
They have calculated for 47 months.
Huh?
47 months.
No, understood. How do you calculate for 7 months? This is for what? Unauthorized use of electricity.
I have to take instruction of that.
No. You are the person you are doing, you have to do it.
Yes.
Now the question is, what is your basis? You are asking this amount on the basis of no escape assessment.
No, my lord, not an escape assessment.
Because you see, there was no load given
Yes,
to them.
yes,
Unless you say that there was a load used
yes.
by them.
We have,
What is your basis to claim on 367 for this period?
We have only charged them in the fixed charge. We have the fixed charges.
But you did not release the load till 29/3/2019.
My lord, on that count only, my lord, I'm submitting here, my lord. My lord may see at page 164 once.
No, I'm not going to look. You answer to this question.
Yes.
You see, you can very well charge.
Yes, my lord.
You are charging on 367 kilowatt,
Yes,
which commensurate to 432 kVA.
yes, ma'am.
Okay. Now, how can you really ask for that when, as on that date, you did not give them that load? One, it is the fact that the load was released only on 29/3/2019. There's no quarrel with that proposition. One. It may be a case of unauthorized use of electricity. It may be the second option. Let us take the best of the best. You can't have beyond 12 months. Mandate of 126(5). That is there. And on what basis you are calculating this amount?
My lord, from April 2018, he was having a record maximum demand of 5092 kilowatt. In July 2018, he was having maximum record of 49112 kilowatt. August 2018, he was having 494 kilowatt. And in March 2019, he was having 5040 kilowatt. This is the finding of the consumer CGRF at page 164.
Understood.
Yes.
So therefore, at that point of time, they was without the load being given to him.
Yes,
Now, you see, earlier, he was using how much? 4,500
was the sanction demand.
was the sanction.
Demand.
And it goes to how much?
5,750.
5,750
Yes,
kVA.
KVA.
So these 5,750 which kVA which he was having,
Yes,
out of that he was using how much? Because that was already sanctioned. Did you take away from him? You didn't regularize.
no, we didn't regularize.
So you didn't regularize. So you didn't take away from him that.
No.
So he had that.
Yes, 4,500 he had.
He had.
Yes,
Now in that, there could not have been additional because he had that 5,200.
yes. My lord, he had 4,500.
And his connected load was?
His connected load was 5750 kilowatt. As per his own agreement at page 2, at page 10, as per the agreement. So
As per the
450.
agreement,
I mean, this-
no, understood.
Yes.
He declared his 5750.
Yes,
He declared. You did not regularize.
we did not regularize.
Although you were required to do so in terms of clause 3.
Yes, as for the regional scheme.
You were required to regularize, but you have not. Be that as it be. Thereupon, and you did not touch on his original load.
My lord, we did not touch upon his original.
So these 4,500 kilowatt, which was given to him,
Yes,
he continued to have it.
yes, he continued to have it.
Now thereupon, during some inspection or otherwise, which you say,
Yes,
there was excess.
yes.
uh,
5750 was
5750 was never found.
found, my lord, tactical.
5750 was found on 27/3/2015. We are not concerned with that.
Yes.
Forget about that. That issue has gone for a 6. In subsequent periods, which you say in 2018, 17, 18,
Yes,
you say that there was a further additional amount, it is some excess consumption beyond the 4,500.
yes,
You say,
yes, ma'am.
did you make any provisional bill assessment? I'm asking you, did you carry out any provisional assessment?
On the additional that happened.
Because that would be an unauthorized use of electricity.
Yes, my lord, that would be-
You did not.
we did not have. I have taken instruction on that. but-
Obviously, you didn't, because this formula which is given at 84 does not resemble that.
Yes, ma'am.
Now, on what basis are you going to ask this amount? If you are on one hand saying that he is in excess,
Yes,
so you have not done that exercise. So that has gone up. And it appears from your own thing that you are not. Now you are asking on what amount? That look here, this 367 is the kilowatt. They had asked for additional amount or something to that effect because they say that 4,500 was there. So they want another 4,837 or something to that.
4,800 total connected.
To that. So they want that. So therefore, now what you do, this application was filed in the year 2018.
In fact, the application for additional loan itself was filed on 25/5/15. It was forwarded to various authorities.
No, it was filed on 24, 2015.
25/5/15.
25 or 24.
Page 53.
No, 22/4. I'm telling you, na. Consumer applied for load
It
sanction.
was
on-
an application for revision of loan, but they were not acted over because contract demand agreement was never not withdrawn. And that is also finding is recorded in campus.
No, anyways, so you
My application,
ask this 367 from where? When you don't release till 2019. It is your admitted stand, which could be seen in page number 70 of the IA, that you release the contract load. The load was released on 29/3/2019.
My lord, before that, I'd like to take my lord, late that on 2018, there was another inspection that was happened in the premises where the total load was 4497 kilowatt with 2 cement mill and 825 and 1 raw mill. Although the consumer submitted a draft agreement of demand contract 4870 on 30th May 2017, but in subsequent months of April 2018, July 2018, August and March, his record maximum demand was more than that.
I understand. So why haven't you taken action under 126? You have not taken action under 126. What is your action therefore? You could have very well taken action under 126, which you did not. What is it? Therefore, I was saying there are two modes. When there is an additional load being given, for that a fix, which has nothing to do with unauthorized use of electricity, where they have to pay as per what is the rates. Now you are asking for these rates of 367 for a period from 2015 to 2018 or 19. You are doing it without releasing this. Whereas what action you should have taken is that without we giving you the additional sanction, additional contracted load, additional contract connected demand or the agreement demand sanction load, you have used more than that. And there is an unauthorized use of electricity for which this is the provisional assessment, this is the final assessment, which you have not done.
And what we have built in is only on the unrealized fixed charge to the period of the sanction limit. That is what.
Understood, but that till 2029/3/2019, you have not given him the load.
My lord, the load which we have charged upon is on the load that we inspected on 27/3/2015, that is 5750. And on that load, the fixed charge has been calculated, and on that fixed charge we have paid. In 2019, he has been making the payment, and that has been observed by the order of the appeal of the consumer. CGRF has categorically mentioned it in its order that he has been paying undoubtedly that amount. Then when the audit objection came that this fixed charge should have been this much, why haven't we collected the fixed charge? Then we gave him the supplementary bill on the fixed charge, calculating it from the year of from 2007 to 2015. And that is why he had raised the issue of that this bill.
But did you raise the fixed charge for calculating the fixed charge?
Yes, sir.
You are required to release the load also. Where is your agreement to the effect? Are you not required to have an agreement for that?
My lord, I absolutely put on what my lord is suggesting. But my lord, there is on a sequence of events. on 27/3/2015, his sanction load was 4,500. That there's no query in it. We inspected 5750 cable. He panicked, he applied for a voluntary load scheme. His entire case was that you cannot charge me the fixed charge of 5750 only because I had applied for a VDL scheme. You have delayed it. Now you have sanctioned it on 8. Our entire assessment and our entire fixed charge that we have been charging him is on that 5750 demand, which he has not been allowed to take. And that is why we have taken that is why we have charged on that fixed charge. That amount, 50 lakhs rupees. That it's on that amount of my lord. It is not is the sanction load which my lord is
No, let us again come back to the basic. He had 4,500
sanctioning.
sanctions,
Yes.
AV, KW.
KW.
On inspection, it was found 5750
Yes, madam.
on 27/3.
Yes, madam.
He applied on 33. That kindly give me the connector, my connected load is 5,000 so and so, along with an agreement
Yes, madam.
for having that. Thereafter, what he does, that look here, this 5750, what is there. But I will have a contract demand at 72%,
Yes, madam.
which comes to 4870.
Yes, madam. Yes, yes.
KW. Now, this he wanted to regularize.
Yes.
Did you regularize it? You regularize this only on 29/3/2019.
Yes.
But you are now asking him to make payment of the fixed charge of 367,
Yes, madam.
which is the regularization period which he sought for, you did not give it till 29/3/2019. And this fixed charge, you are now asking for that period.
Yes, that is the case.
That's the case.
Yes, madam.
Now, if you say so, but if you have released it only on 29/3/2019, how can you do so?
My lord, as because my lord, because as per the VDS scheme, my lord, there was a step was that he has to voluntarily declare it. He never declared it. Second of all, my lord, as per his own appeal which he has filed.
Okay, let us assume
Yes.
his application dated 33/2015 is not a voluntary declaration.
My lord, it was not been received. There was no signature of receipt.
Okay, let us assume that. But however, the various documents which have been issued by the area manager, general manager and all,
Yes, madam. Internal copy.
categorically mentions that he has submitted.
Yes,
You can't quarrel with those documents.
yes.
So therefore, can we now question that there is no receipt?
No, I'm not on the receipt. madam.
No.
Yes,
So therefore, the application which is being filed on 33/2015 is a fact which your people have duly acknowledged.
my lord, on that.
What do you say about this document then? Kindly come to page 52, 51. Page 50. This is a document on 31/3/2015 issued by the same area manager who has written the letter at page 70 of his I.
Yes, madam. So my lord may see here, if I, God permit me.
50.
Yes. If the contract demand effect can be allowed to the consumer.
No, not there. But the fact remains that this particular area manager
Yes.
duly acknowledges that he submitted this document.
Yes,
So you can't raise that issue now. It is closed. And this also is being duly acknowledged by the next higher up, that is the general manager at page 51. So this is very clear from these two documents. So he applied on that day. Now, if you say, then look here, the moment he applied, automatically he is being granted the sanction. That is not your case. Then how are you going to claim for the period till you don't give release the load till 29/3/2019 on account of the fixed charge? Isn't that, Mr. Kejriwal, the case?
Look,
Isn't that the case?
it is the case.
Precisely, instead of going into so long and these are the 5 dates, these are the 5. You could have very well gone for a provisional assessment that without granting you the additional load, you have used it. After that, also you have used it. We have not given you the clear declaration, anything to that effect. So therefore, you are unauthorized use of electricity. You do whatever it is. This is wrong, right? But the fact remains that you are asking only for a fixed charge.
Yes.
But you are not released for that fixed charge. This is the question. Enough.
I don't know, please give me one more date to satisfy, just one. Next week of November, any, just a date, just to, if I may something.
You inquire with your people as regards these documents. And then you, but this is it.
I put on.
2 electricity matters I could not finish.
My lord, if my lord, on your request, on my request, or just this, I need.
This is the only issue.
Yes, my lord has taken, if I can satisfy your lord in my point of view.
You go for unauthorized use of electricity is a different aspect.
And now,
But this is another thing. And if you go for unauthorized use of electricity also, as of now, you can. But if you then go to the civil court within the period of limitation.
Lord, in fact, the dates on which the overdraw is concerned with the excess law. They have issued overdrawn bill as per the schedule of tariff. It is not that they have not charged excess for excess consumption, they have raised the bills. And that was never an issue, that is why they has not been decided.
Chalo, heard Mr. S.P. Sharma, the learned counsel appearing on behalf of the petitioner, as well as Mr. S.K. Kejriwal, the learned counsel appearing on behalf of the respondent number 2. By the present petition, the petitioner have assailed the order dated, the judgment and order dated 25/9/2024, whereby the respondent authority, whereby the is that whereby the Assam Electricity Regulatory Commission.
Electricity Ombudsman.
Well, it is given as Office of the Electricity Ombudsman, whereby the Electricity Ombudsman working under the aegis of the Assam Electricity Regulatory Commission held that the bill which was issued to the petitioner, issued to the respondent number 2, dated 5/1/2023,
Dated 21/12/22.
dated 21/12/2022, was not recoverable from the respondent number 2, as well as other further directions. from a material, upon hearing the learned counsels appearing on behalf of the petitioner, upon the of the parties, it appears that this bill dated 21/12/2022 was challenged by the respondent number 2 on the ground that the said bill could not have been realized, imposed upon the petitioner, upon the respondent number 2. For the fixed charge of 367 kilowatt kW, which corresponds to 432 kVA. Inasmuch as with effect from 1/5/2015 to 29/3/2019,
28.
to 28/3/2019, the load, the additional load which contract demand load, which the respondent number 2 sought for, that is 367 kW, was not released to the respondent number 2, and it was only on 29/3/2019 the said contract demand load was released. Therefore, it is the case of the respondent number 2 that the said amount, as mentioned in the bill dated 21/12/2022, was not recoverable from the respondent number 2, and this aspect have been approved by the Learned Electricity Ombudsman working under the aegis of the Assam State Electricity Commission. What is that?
Assam Electricity Regulatory Commission.
Regulatory Commission. Mr. S.P. Sharma, the Learned Counsel appearing on behalf of the petitioner, submitted that he would like to obtain instructions from the respondent, from the petitioner. Further instructions. First, taking into account the above, lists the matter on 22/1/2026 at 2 p.m. for further hearing.
Further hearing. For further hearing.
Salmia, what is there?
Regarding settlement.
Oh, that one. Yes. Terms with clause 36, there was a requirement. Yes, about both. Yes, you filed your reply.
I filed it. I filed the return.
Oh, yesterday, 3/12, no?
Yes.
Yes. What is your stand?
So we have taken the step, my lord, first of all, my lord. The inquiry was conducted, my lord, by the EDO, the IWP officer, and they have found that there is no discrepancy, my lord. And moreover, under the rules, my lord, under the clause 36, my lord, there is no bar that I cannot hire the worker. And moreover, my lord, as per the
Indian vessel there.
As I told you,
Yes, sir.
you can.
Owner includes operator. Owner includes operator in section 19. It only says that owner and master of the Indian vessel, inland vessel shall carry a valid cert. So owner includes operator. So I am the operator under section CZC.
You have the license.
License is private.
License. Don't come into this problem. It's a very dangerous problem. To raise this, there's a big issue. You need to have a license issued under this act. Isn't it? I've dealt it with another judgment. Don't come up, bring this aspect.
But the clause 36, it doesn't
Because
say.
there the issue which was there was this owner, he was given a hut. When the hut was given, so what he did on the first day, the second day he gave it to somebody else to run it. Then after 4 or 5 days, when these people were looking into IWT, were looking into and found that somebody else is there. So he said, look here, I've been given authorization to run it. On the basis of that, he took it and he cancelled it. First round, the second round. The second round came before me. When it came up before me, the question which was asked is that, look, yeah, I can run it. And these were just my helpers and all. Then, upon further inquiry being made, when I asked for some documents and all, it came out that he is actually an operator in some other vessel. And once he's an operator in that vessel where there is a certificate being given, he cannot use it. And the operator will also have the name in which vessel. You have it. That is the judgment. He got it.
The clause 36, it doesn't say that I cannot hire it. And moreover,
You stick to that argument. Why don't travel to this inland? Inland is a very dangerous.
And clause 14 says if otherwise found eligible. Clause 14 of the tender condition, it says if otherwise found eligible, because first the prior.
Now, you may very well submit that it does not say that he has to be a owner. Is it said?
Clause 36 doesn't say, madam.
There was a requirement that the bidder should own a boat. However, the private man does not own a boat.
But if the SMEs is read, madam, বই পঞ্জীয়ন থকা আৰু নাও ফেৰী চলাচল ক্ষেত্ৰত বাধ্যতামূলক সুৰক্ষা ব্যৱস্থা গ্ৰহণ কৰা নিবিদাকাৰীসকলে ফেৰী নিবিদা প্ৰক্ৰিয়াত অংশগ্ৰহণ কৰিব পাৰিব। নিবিদাকাৰী নিবিদা প্ৰপত্ৰ সংশ্লিষ্ট নাও ফেৰী শেহতীয়া ফিটনেছ চাৰ্টিফিকেট জমা দিয়াটো বাধ্যতামূলক। উক্ত ফিটনেছ চাৰ্টিফিকেট অভ্যন্তৰীণ জল পৰিবহণ বিভাগৰ কৰ্তৃপক্ষ।
Now, what do you say? Does he meet the clause 36?
My lord, as per their writing for document, which was conducted by our officers, my lord, it says, my lord, the documents are open.
I'm not on that.
My lord.
Whether a person who is not the owner of the vessel can participate. That is a very important issue.
As per my
What is your stand?
As per my understanding, my lord, if before participations, he already with a various document, he can procure that vessel that.
What is the valid document as per you?
The license to run that vessel.
License by how?
License by the authority, the competent authority is the identification.
License to whom?
License to the owner of that.
But if the owner of the vessel is there, can it be run by an operator? If he's not the owner, can he lease it out? Because all these other acts, all the central, all the local acts, is being taken over by this inland water
In
vessels.
our budget, act, my lord, there is nothing. That kind of
But
thing.
Mr. Council,
I don't
this
think-
Inland Water Vessel Act
Yes.
applies to all
Yes.
waterways,
Yeah, that is
including
why,
your panchayat.
that is why registration is mandatory, but.
So including panchayat.
Yes.
So therefore, you see, every aspect, even who are going to ply the vehicle
Yes,
is also to be mentioned.
yes,
Not only here, even the rules which are being framed by the state government.
yes.
Now, what is your reply therefore in terms with section clause 36?
Why not in this issue, why not perhaps IWT and city can help, why not? Because
No,
probably-
you have to tell me as to whether you have looked into that aspect. You say that he is possible, means therefore, are we therefore to go that panchayat and rural development department thing is forget about inland water, it's a central government act, we don't look into it. As per us, they can point. Can you say that?
Why not authority, they at that point look into or not?
No, I'm asking you. You are the PNRD,
Yes,
the big officers they have. So you have to come up with that
I'll go through it.
next week. Next week, you have to come up with that aspect as to whether in view of what he says, he has taken on loan.
Right.
And in terms with the inland act,
That is permissible or not?
permissible. Because if it is, the law does not,
Yes,
the tender condition cannot.
fine. I understand.
An affidavit has been filed by the additional affidavit has been filed by respondent number 7 to the rejoinder filed by the petitioner. A specific question have been raised in respect to clause 36 of the NIT. It is being submitted by Mr. K. Day, the learned counsel appearing on behalf of the petitioner, that clause 36 of the NIT cannot be taken out of context of the Inland Vessels Act 2021 and the rules framed therein under by the state government. He therefore submits that there is a requirement to Mr. As Dr. Learned Standing Counsel is directed to apprise this court on the next stage as regards as to whether the private respondent herein, being not the owner of a boat in question, would be eligible to participate in terms with rule clause 36 of the NIT, read with the Inland Vessels Act 2021. List the matter again on 18th of December. Okay. 2 p.m.
Item 19.
And you see here, this judgment, take it from here. Motilal Abidas, appearing on your reply. 9.
Item 9.
You got tired out there. Yes, well, you have not filed your affidavit.
Yeah, I have had it.
They have also filed reply. Okay. List this matter. By taking into account that the pleadings are complete, list the matter on 5th of February 2026, on which date an attempt will be made to dispose. of it. Yes, what is this? It would be more time for essential for the purpose of filing the affidavit, and affidavit is essential and these things. Affidavit filed,
Record of the call.
what is that?
On 14 Fellows, the order dated 14.
Rank of junior officer was promoted to the post of CEO without fully. Oh, that one. Reply has been filed. Affidavit in opposition. Fine. And where respond number 6 has also filed. You have filed a reply? No,
No,
you don't want.
but the records were there in the record.
I'm asking you, do you want or do you don't want?
Short reply, I mean,
I'm asking you, that is your lookout. Later on, don't come up and say that, my lord, I want to withdraw.
Lordship, I will file a short reply on
Mr. B.P. Bora, appearing on behalf of the petitioner, submits that taking into account the reply filed by the respondents, he would inquire, he would the petitioner be given an opportunity to file a reply to establish the matter again on 5/2/2026. In the meantime, if any replies to be filed, the same be filed. Where there is an interim order or thing?
yes, but on the last occasion, on 14th, interim was given.
What is that? Considering that the imam which was there has been promoted to the post of senior state. The materials and privacy of the promotion made to the favor of the imam is nothing concerning the life here. And how the senior to governor right to be about. Oh, that is why, nah. So I've stated.
Yes, madam.
But anyways, we don't have time, right? That 8th is there. You want to do it on 8th of January? 8th good. Reply be filed in the
11.
reply you file by 5th, huh? Umesh, Sri what is this pension?
Provisional pension already paid, madam.
Paid. Now what do you want?
Only there for provisional pension.
Nothing more. Okay, it has been submitted at the bar by both the councils appearing on behalf of the parties that the petitioner is now presently being paid the provisional pension. So taking into account the scope of the present writ petition, therefore, the instant writ petition, the grievance of the petitioner have been duly redressed. Accordingly, the writ petition stands closed.
Give them.
Take a paragraph wise comment.
Madam, I have filed the affidavit on behalf of my responding number 2 today, madam.
I need some time to give response to. Number 2.
Madam, I have filed it.
Okay, the respondent number 2 has filed an affidavit in opposition, however, the same is not on record. The Guwahati High Court, however, have not filed any affidavit in opposition. The council appearing on behalf of the petitioner seeks an opportunity to file a reply to the affidavit in opposition filed by the respondent number 2. List the matter on 5/2/2026. In the meantime, the Guwahati High Court shall file the affidavit on or before 27th of January 2026. Liberty given to petitioner to file reply, if any, on or before the next date. As regards the reply to be filed against the affidavit in opposition of the respondent number 2, the petitioner is given the liberty to file the said reply on or before 2nd of February 2026.
Order item 30.
Oh, dear Basa, where is he? What? Good. Not only me, there are other courts also keeps on sitting.
So the meetings are completed. Next on page, we have issued the work order, respondent I to file doing the work from 1 of February. 16 January. January.
Your senior is busy at 4:45 in other courts. When the court sits till 4:30. Which other court is appearing? Chalo. A perusal of the, so it is seen that an affidavit of service have been filed by the petitioner insofar as affecting service upon the respondent number 5. This court can't accept the said affidavit of service, taking into account the direction to take steps by way of Dusty was issued on 24/5/2025, and the case was directed to be listed on 21/5/2025. However, this affidavit of service is filed today. Under such circumstances, this court therefore rejects this affidavit of service. The learned counsel appearing on behalf of the petitioner submits. Who is appearing for respondent number 5? Okay. Where is the respondent number 5? Chalo. Submits that there is an urgency in the matter. Taking into account that the respondent number 5 is working. This court inquired with Mr. B. Gogoi, the learned senior standing counsel of the PWD department, under whom, as to whether the respondent number 5 is presently is carrying out the contract work. It is submitted that the respondent number 5 is presently carrying out the contract work. Under such circumstances, this court therefore directs the counsel appearing on behalf of the petitioner to serve an extra copy of the writ petition upon Mr. B. Gogoi, the learned standing counsel of the PWD, who shall effect through the executive engineer PWRD, Nalbari District Territorial Division, service of the notice of the writ petition upon the respondent number 5, as for the work in question, the respondent number 4 is the concerned engineer. List this matter again on 28/1/2026. An instruction be placed before this court on the next day by the respondent number 4 as to whether the directions so passed herein above have been duly complied.
I can pertain.
What is this high business?
Page number 17.
Typographical error in my judgment. Which judgment?
Judgment dated 30/10/25.
Huh?
Page number 17, para 6 yellow.
Page number
17.
17. What is this?
Para 6.
It is a type copy.
No, yellow.
Para 6. What has happened?
And fourth line, the respondent number 8.
Para 6.
Para 6. Respondent number 6 or 8.
The promotion of the respondent number 8 is in accordance with the principle. The learned counsel further submitted that the petitioner is not aggrieved by the promotion of the respondent number 8 by the impugn order dated so and so. Except, and what did it say when accept that the promotion of the respondent is in accordance? What is wrong?
Respondent number 8 was not promoted. Respondent number 8 was also a private party. Whether a Supriya Chakraborty was promoted, and he was not made, she was not made a party. And
Respondent number 8 was not made a party.
No, respondent number 8 was a party, but he
Uh-huh.
was not promoted. Our grievances not against the respondent, Supriya Chakraborty. She was not a party and she was rightly promoted. That's why we do not, it
petitioner does not have any grievance against Dr. Supriya.
Respondent number 8 is the party Sukanta Das.
Sukanta Das was not promoted. He was also supposed to be one of the petitioner, but he does not come with us. So we have preferred this petition, making him as a respondent.
Then
Then the petitioner number 8 is Supriya Chakrabarti. She was rightly promoted and we does not have any grievance
Who?
against her.
who was rightly promoted?
Your Lordship, a order dated a 21/8/25 notice.
No, who was rightly promoted?
Page number 22 notice.
Where is my interim order?
Yes, interim order,
Given all details. Where?
para 5 yellow.
There, yeah, page 20, 25.
20, running page 22.
Supriya Chakraborty. She got 46.
Yes. She was rightly promoted and we do not have any objection against her.
Okay, then
So,
Sukanta Das, 30.
here the page Supriya Chakrabarti at the top of the list. And
But she was not a party.
she was not a part.
Okay, why have you made Sukanta Das a party?
Sukanta Das was supposed to be one of the.
You are for the High Court.
No, you-
Why you are making all this submission? This is a submission made by Mr. H.K. Das. I did. No, this, you are paying for the High Court. Who are you?
I'm for the petitioner.
Therefore, I'm saying it should be paragraph number 6 at page number 17 is the submission of Mr. H.K. Das. So it is he who has to ask for correction. It may have been his mistake. What I did is, the respondent would like be at liberty to take steps of filling up the vacant post of senior which now stands vacant in view of the setting aside of the order by which so and so have not interfered with the impugned order of area insofar as promotion of respondent number 8 to the post. So respondent number 8 has not been promoted. Okay.
In view of respondent number 8, would have been Supriya Chakrabarti.
Where is the order of promotion?
Order of promotion at page 28.
Supriya Chakraborty is hereby promoted to the post of Imam. And where is your Sandeep Chakraborty is hereby promoted to so and so.
We are telling the promotion of Sandeep Chakrabarti.
This is a typographical, we corrected it. Where is my order? Page 17, no?
There are 6 and 8.
Heard Mr. So and so, the learned counsel appearing on behalf of the petitioner. Mr. T.J. Mohanta, the learned senior standing.
Yes,
The senior standing counsel of the Guwahati High Court, assisted by Ms. D. Mohanta. This is an application seeking correction of the order dated, the judgment and order dated 30/10/2025 passed in WPC number 4759/2025, wherein this court have referred in various paragraphs that the respondent number 8 have been promoted by the impugned order dated 1/8/2025. The learned counsel, appearing on behalf of the petitioner, drew the attention of this court to the impugned order dated 1/8/2025, wherein once Supriya Chakraborty was actually promoted to the post of Senior Administrative Assistant, bracket formerly known as Upper Division Assistant. divisional assistant. This court had duly perused the impugned order dated 1/8/2025, and it is the opinion of this court that there has been a mistake committed by this court in the order dated 30/10/2025, taking into account that on account of a mistake committed by the court, the litigants should not suffer, this court therefore is of the opinion that this correction is required to be carried out. Accordingly, the reference to the respondent number 8 at paragraph number 6 and paragraph number 8 of the order dated 30/10/2025 in WPC number so and so shall be read as Srimati Supriya Chakraborty. The instant order shall be a part of the order dated 30/10/2025 passed in WPC number so and so. I stand disposed. Anything more? No, today these electricity matters have taken the time, the toll. And at the end of the day, the matters didn't take place. Absolutely no. I don't have the time. 18/2. Why should I have it? Why? Can't be urgency of you because today in the morning you were asking for adjournment. You are asking for adjournment. You are enjoying an interim order. But from January onwards, I am no more taking the High Court matters. So after January. After January. Okay, no. You have taken one adjournment last time.
No, my lord.
Yes.
No, I don't know. In morning I asked.
I therefore said that I am going to vacate the interim order last time. Remember?
No,
No.
That day was my daughter's birthday.
Okay.
I
Then we'll need things.
I stayed till 5 minutes.
Okay. At least the matter taking into account that Mr. H.K. Das, the learned counsel for the Guwahati High Court, could not be present today on account of a certain official engagement, list this matter on 18/12/2025 for further consideration. Interim order passed earlier shall continue till then. What?
Item number 15.
Matter pertains to? Hearing? What hearing?
Matter pertains to the special, protected employee, the product for. I think the award of the labor code.
Have it on 22nd? 28, 29.
29 January.